And then there is lastly the Audi point. Obviously, if you find that the report is invalid, unlawful, because the President was not afforded a fair hearing, you won't get to the point. If you do, however, contrary to our submission, do get to that inquiry, whether if you conclude that the Executive Code did not require disclosure of these documents, then you reach Amabongane's application. And then the question is whether the code is unconstitutional for its failure to require disclosure. Remember, the premise of the application is your finding that the code did not require disclosure of campaign donation. Amabongane says, well, I don't enter that debate, but if that is what you find, then we argue that the code is unconstitutional and invalid. And that will raise questions of fact and questions of law. The first question of fact will then be, well, what was the nature of the CR17 campaign, and how did the President and the other candidates supported by the campaign, how did they benefit from the campaign and from the donations to it? It's again an inquiry which will already have been addressed in the first round in the President's application on the nature of the CR17 campaign and on the effect of the donations made to the campaign. So, and that is the issue that I've told you my learned friend Mr. Kakobi will address, and therefore it is an issue which straddles both applications. He will address that issue and I will simply receive from it. But the point that we make here, the conclusion that we urge you to reach on this campaign, is that Amabongane's glib statement that this case is about donations made to the President or in his name is, with respect, absolutely unfounded. That is not what the case is about at all. That reflects a very serious failure to have regard to any of the evidence which is unchallenged and undisputed in this case about the true nature of the CR17 campaign. So in the campaign they postulate, the campaign Amabongane postulates, is a campaign by one candidate for an election, one candidate directly for an election to office in a political party. And that is so far removed from the true nature of the CR17 campaign that there is actually no comparison between the two. Again, what my learned friend Mr. Kakobi will address, but we just emphasize that the foundation of fact on which Amabongane bases their case is a misconceived basis of fact. They make glib statements about election campaigns generally for positions in political parties without any attempt to engage with the actual facts of this campaign and what it stood for. It wasn't just an election campaign, it was a campaign for advancing political and ideological causes in the first place, and then a campaign for the election of a large number of people, including the then Deputy President Ramaphosa, but also a large number of candidates for election to the NEC of a party political campaign. In other words, a private election, not a public election. But I'll move on from there, because the question then is whether any of the causes of action which they raise, any of the grounds of attack on the code, are valid. And they're frankly not so explicit about their grounds of attack. They are rather obscure about them because they toss in and mix them up statements about Section 32 of the Constitution, Section 19, Section 96. So what we've tried to do is to disentangle them and deal with what we understand their causes of action are, to demonstrate that none of them founds a valid ground of attack against the code. We start with Section 32, read with Section 19 of the Constitution. We deal with this in our heads of argument in our Amabungane heads of argument from page 16, paragraph 42. And we articulate what we understand Amabungane's argument to be, because it's not always clear from their heads of argument what it is that they argue. But they seem to us to say their starting point is section 32 of the Constitution, section 32(1)(b), which provides that everyone has a right of access to information, and we quote, that is held by another person and that is required for the exercise or protection of any rights. They then read that section with section 19(3)(a) of the Constitution, which vests every adult citizen with a right to vote. So they say, in order to exercise that right to vote, voters require information about the campaign funding of the candidates in the election, and voters are accordingly entitled, in terms of section 32(1)(b), to particulars of the campaign funding. That seems to us to be their argument under section 32 read with section 19, which was also the foundation of the attack in My Vote Counts 2, the attack which succeeded in My Vote Counts 2. But the attack which failed in My Vote Counts 1, the first My Vote case. And that is that it firstly suffers the same fatal defect as the application did in My Vote Counts 1. And that is that it is an attempt by Amabungane to launch a constitutional attack on the code directly under section 32. And that is in violation of the subsidiarity principle, which the Constitutional Court has repeatedly recognized and which the Constitutional Court upheld in My Vote Counts 1. That is the basis on which My Vote Counts 1 failed, because it was an attempt to launch a direct application under section 32. The Constitutional Court said, no, you cannot do that, because Parliament has enacted PIA, Promotion of Access to Information Act, has enacted PIA in order to give full effect to section 32. That was the avowed purpose of PIA. And when Parliament does that, when it enacts legislation to give effect to a constitutional rule, then anybody who has a grievance has to bring the grievance under the legislation and is not allowed to bring the application directly under the founding constitutional section. And for that reason, said the Constitutional Court in My Vote Counts 1, said you can't come here with a direct attack on Parliament under section 32 of the Constitution. You have to make your case under PIA, and if needs be, attack the constitutional validity of PIA for its failure to include the provisions which you say it should have made.
Mr. Pringo, can I ask you a question there? It seems that they might try to avoid the subsidiarity problem by saying our attack is really based not on 32, but on the interpretation of the Act and the Code.
Yes.
And so we fall within the ambit of My Vote Counts 2 rather than My Vote Counts 1.
Well,
does that go to one of your later points, that it's the wrong
target?
Yes.
But let me also say this. Parliament said in so many words, and the Constitutional Court has held, that PIA is Parliament's information section. It has been enacted to give full effect to section 32. And that is the ratio of My Vote Counts 1. And it's not one of those cases. There are some constitutional rights, for instance, the right to fair labor practices, which has been given effect to by a whole number of different pieces of legislation. You can't ever say any single act was designed to give full effect to all of them. But in the case of section 32, Parliament says in PIA, and the Constitutional Court has held, that it is meant to cover the field, underpinned by section 32. So you can't, and when you come to 32, You can't launch an attack under Section 32 directly because you have to come via PAYA. Milady, they do raise grounds other than Section 32, and I'll address them shortly. But simply as far as the Section 32 attack is concerned, the ratio of my vote counts 1 is dead against them. And if I may just quote from the Constitutional Court judgment in our paragraph 44.3 and 44.4, we quote from my vote counts 1, but these were indeed endorsements of quotations from earlier cases. So these are well-established principles where the court said, where legislation has been enacted to give effect to a right, i.e. PAYA, a litigant should rely on that legislation in order to give effect to the right, or alternatively challenge the legislation as being inconsistent with the Constitution. And then they deal specifically with Section 32. Whereas here, that's a Section 32 attack, the Constitution requires Parliament to enact legislation to give effect to the constitutional rights guaranteed in the Constitution, and Parliament enacts such legislation. It will ordinarily be impermissible for a litigant to found a cause of action directly on the Constitution without alleging that the statute in question is deficient in the remedies that it provides. And we submit that the same applies to this case. But of course, this ground of attack is not based only on Section 32, it's also based on Section 19. Section 32 gives the right of access to information, but only required for the exercise of a right. The right they find, that's the second leg of this attack, in Section 19 of the Constitution, and that is the right to vote in elections. But that again is a right to vote in public elections. It's made plain in the section itself. And in fact, in my vote counts 2, the court specifically and repeatedly made the point that what they were talking about is the right to vote in public elections. There's actually a footnote. We mention it in our paragraph 46.2. A footnote in paragraph 3, footnote 4, where the court referred to an English case and then said, but for our purposes, what we're talking about is participation in public elections or elections for public office. So that the Section 19 leg of their attack is also irrelevant when one deals with the private elections in private organizations. And for that reason, too, the attack must fail. There's a third reason why this Section 32 attack must fail, and that is that Section 32 only applies to information held by another person. Now let me say, there was a bit of debate in my vote counts 1 about the meaning of that requirement. But that debate does not concern us. And let me just explain why. The question is, what does it mean to say information held? You know that PAYA is confined to records in the possession of the respondent, and therefore it is confined to information held in record form. So said the Constitutional Court, but is that the only way in which information can be held? What if it is in your head, but not on paper? Is that information held? Or can a political party escape the PAYA disclosure by simply not recording the donations they receive? So there can be a bit of debate about what it means to speak, what it means to hold information. Does it have to be on a piece of paper or in a computer? Or do you also hold information if it's in your head but not on a piece of paper? So we acknowledge that there is a bit of debate about precisely what that requirement means. But what all those meanings have in common is that it is confined to information you have available, someone has available to themselves. In other words, you can't ever have a right of access to information against someone who doesn't have the information whether on paper or in their heads. So and in this case, the undisputed evidence of the President is that generally speaking, not absolutely, but generally speaking, he and the fundraising committee of CR17 had agreed that they won't tell him who had given what. So if you want information about who had given donations and how much they've given, the President doesn't have that information. He doesn't hold that information.
He could get it, though.
He could. Well, let me say,
Possibly.
yeah. He hasn't excluded the possibility that he might be able to get it. Let me say immediately, he's an influential figure in CR17. But that again is not the constitutional test. The constitutional test is not information that someone else is able to get from somebody else. It's not access to information held by somebody else. And the President doesn't hold that information. That is the Section 32 attack. Then Amabungane makes an attack under Section 96 of the Constitution. But what Section 96 says is Section 96 simply says that there must be a code of conduct made which governs the conduct of the executive. That is what Section 96 says. The section does not prescribe in any way what that code must say. And we submit with respect that Amabungane is completely unjustified in their suggestion that the Constitution requires the code to require disclosure of any particular kind. And why it is important is that it comes back to a point that the court made in My Vote Counts 1, where where the Constitution leaves it to Parliament to determine what should go into a code of that kind. Then the Constitution leaves a wide discretion to Parliament to determine what should go in it. And it is not within the bounds of rationality, not for the citizen or the courts to prescribe to Parliament how to do it. And we quote on page 20 of our heads from the My Vote Counts 1, where the court said, "It is for Parliament to make legislative choices, as long as they are rational and otherwise constitutionally compliant. Crucially, lack of rationality is not an issue in these proceedings. Despite its protestations to the contrary, what the applicant wants is but a thinly veiled attempt at prescribing to Parliament to legislate in a particular manner. By what dint of right can the applicant do so? None in the present circumstances." And we submit that the same answer is an answer to our Mongani. If one then, those are our submissions on their Section 32 cause of action, or Section 32, Section 19 cause of action. Then they have a set what seems to be, and 96. Then there's a separate attack under the Ethics Act. But the Ethics Act, the code does exactly what the Ethics Act required it to do. And what I mean by that is, the code uses the same terminology as the Ethics Act in requiring disclosure. The Ethics Act requires disclosure of the financial interests of members of the executive, and that is what the code then does. It requires disclosure of the financial interests of members of the executive. Now, we can have a lot of debate as to what financial interests mean, and that is one of the debates we'll have by then, by Toby. But it cannot be contended that the code does not meet the requirements of the statute, because the code uses the language of the statute. Whatever the meaning is of financial interests, that is the requirement of the Act, and that is also the language of the code. So however one interprets that requirement, you cannot conclude that the code does not meet the requirements of the Act, because both of them use the same language. Our Bungani then in the last place, raise an argument of undue vagueness. But with respect, that argument is not, is ill-conceived for this reason. Amabungane says, my application only gets out of the starting block if you find that the code does not require the disclosure of campaign donations. In other words, only once you have made a positive finding on the proper interpretation of the code, namely that it does not require disclosure of campaign donations, does Amabungane's debate start. Now, so the premise of the Amabungane application is that the court has already interpreted the code and found it, on a proper interpretation, not to require disclosure of donations of this kind. Well, once the court has come to that point, it has overcome whatever vagueness hurdle there might have been. Vagueness is a hurdle and is a ground of attack if you are unable to determine with reasonable certainty what the code means. But the Amabungane attack postulates that you will have made a finding of what it means. We submit in the last place that the executive code is the wrong target. And that is, even if there is some constitutional requirement, whether under any of these provisions, or some of them, or a combination of them. In other words, even if we're wrong on everything you've said, the high water mark of the Amabungane case is that the Constitution requires disclosure of donations of this kind, and that the code is unconstitutional because it does not require the disclosure. But why the code? The code was designed to do something far more limited. Remember, the code we're talking about, the executive code, is something that applies only to cabinet members, national and provincial. Why, if there is a constitutional rule that politicians who participate in public elections, or in any elections for that matter, ought to disclose their campaign funding, why do you blame the code which was created to provide for a separate set of rules for members of cabinet? Surely if the Constitution requires something of that kind, it would be a rule that applies to everybody who participates in public and private elections. So if Amabungane will have their way, it will create a lopsided contest in any elections, because only members of cabinet who participate in party elections will have to disclose their campaign funding, whereas their opponents, who are not subject to the executive code, will not be subject to that requirement. That is a lopsided irrationality, which is the product of picking the wrong target. The target they ought to pick is firstly to say, we submit that the proper target is the new Political Party Funding Act. If it doesn't satisfy their requirement, then attack it for not doing so, because it was designed to regulate disclosure of campaign funding. Or even if we're wrong, if the Political Party Funding Act is not the right target for some reason, then complain to Parliament that they have not given effect to the constitutional principle upon which Amabungane relies. But don't blame the executive code. It was never designed and intended to be the vehicle by which Parliament or the executive give effect to a broad constitutional requirement that people who participate in public and private elections must disclose their campaign funding. So we submit for that reason in conclusion that the court need not and should not reach Amabungane's application, but if it does, that it should be dismissed. There is no question of cost that arises from that application. We don't ask for cost, and I don't think they will. On that note, I turn to my learned friend on the CR17 campaign investigation.
is a 888. (802-890). That is the submission made on behalf of the President to the Public Protector. The court will also find them in the founding affidavit, which is at 0222, and that goes on up to 0231. The supplementary affidavit simply harks back to those two documents. But it is crucial to understand factually what the campaign was about, because we will submit that the Public Protector fundamentally misunderstood the facts. And as a result of the failure to understand the facts, she came to factually inaccurate and therefore irrational findings. What we know about this campaign from page 02875 is that its purpose, and this is expressly stated in the founding affidavit, its purpose was to return the ANC into its traditional values. It was founded on certain principles. Those principles included renewal, honesty, integrity, economic growth, eradication of poverty, reduction of inequality, a society that is non-racial and non-sexist, and a promotion of self-actualization. So it was an idealistic campaign. But what we also know is that it was an idealistic campaign within the ANC. The ANC itself is a private organization. And this should not surprise one, because it is a finding made by the Constitutional Court in the Ramakatsa case, that when political parties inter se their members, they are not acting in the public, but they are acting in the private realm. So, in the first instance, we are dealing with a campaign anchored in certain ideas, but within the purview of a private political organization. The second feature of the campaign is dealt with at 02878, it was a broad political campaign. This is unlike the scenario postulated by Amabungane of a single candidate in an election contesting to win an election. But it is also different from the picture painted by the Public Protector that the President, Mr. Ramaphosa, was involved in a singular campaign for his own election. The papers illustrate that there were 80 positions to be contested at the Nasrec conference. The CR17 campaign supported many candidates, certainly a lot more than Mr. Ramaphosa. It supported them on the basis of their adherence to the principles of moral integrity, honesty, and a commitment to the eradication of poverty. And so it was a broad-based campaign rather than an individual campaign. The third feature of this campaign, which is at 02881, is the structure of the campaign. And the structure is crucial when it comes to the questions of knowledge and disclosure. The campaign itself was not started by Mr. Ramaphosa. It was started by associates of his. But what they then decided was that it would have a robust structure comprised of various committees to increase transparency but accountability in relation to the way in which the funds were received and subsequently expanded. We know this from page 02882, that the framework of the campaign commences with a national campaign manager, who was Mr. Bejani Chauke, a project manager, a political committee, a fundraising committee, an organizing committee, a communications committee, security committee, finance, administration, and logistics. So we have a multiplicity of committees, which, as the papers showed, was intended to ensure transparency and internal accountability in relation to the campaign. As far as the funds were concerned, in the first instance, the funds were generated by the fundraising committee. We know the members of the fundraising committee because their names are in page 02883. It was Mr. James Motlatsi, Ms. Don Nicol, Mr. Sifiso Dabengwa, and Mr. Crispian Oliver. What we also know about this is that the fundraising committee did not include President Ramaphosa. We also know that once the funds came into the campaign, the way in which they would be spent was decided by the finance committee, not even by the fundraising committee, which was responsible for generating the funds. We know this at page 02884. And so it was the finance committee that decided what should be spent on what. And so the structure was a robust, a transparent, and an accountable structure. And the fourth feature of the campaign was the manner in which the funds came into the campaign and the way in which they were spent. Two things require emphasis. The first, which is at page 02886. The first is that, contrary to being a beneficiary of monies generated by the campaign, President Ramaphosa was in fact a contributor, a financial contributor to the campaign. An aspect that the court will notice is completely glossed over by the public protector in her reckless determination to find fault with the president. We know this from paragraph 47 at page 02886. Firstly, the president donates an amount of 200,000 rands. That is a donation. The money is not flowing from others into his hands. It is flowing from his pocket into the campaign. Secondly, we also know that the president at paragraph 50 donates 1 million rands on the 27th of January 2017. At paragraph 53, on the 12th of September 2017, he donates another 5 million rands. And at paragraph 55, he deposits 20 million rands as a loan to the campaign. At paragraph 56, on the 6th of December 2017, he deposits another 10 million rands as a loan to the campaign. And at paragraph 57, he deposits another 1 million rands as a loan to the campaign. So that the combined amount that came from the president's own pocket is 37.2 million rands. No benefit, no financial benefit whatsoever that came to him. So that's the one aspect about the funding. What we also know is that the trust, the Cyril Ramaphosa Foundation Trust, is not a family trust as such. It is a charitable trust. The monies that came into that trust were monies that were subsequently spent in charitable causes that were supported and promoted by the president. And so that when the public protector concludes that by mere reference to the fact that monies came into the Cyril Ramaphosa Foundation Trust, therefore that was evidence of financial benefit, she misunderstands the nature of the trust, which was a charitable trust, and President Ramaphosa himself was not a beneficiary of that trust. And then finally, what we know about the campaign is that a decision was taken quite early on at the commencement of the campaign that President Ramaphosa would be kept at arm's length in relation to who was donating. He would be kept at arm's length in relation to the operational modalities of the campaign. And he would also be kept at arm's length in relation to the flow of the funds, in other words, who was paying where. And so the material information that would ordinarily be necessary or available for purposes of disclosure, there was a deliberate decision taken by the campaign managers, which, as I have illustrated, were both independent and separate from the president, that he would be kept at arm's length for the purposes of obtaining that information. That is completely aligned to the two principles that underpinned the campaign, honesty and integrity. And in order to fulfill those two principles, what they wanted to do was to set up a robust structure which was transparent but also financially prudent and accountable. Now, what happened to the monies that were received? I mean, again, that is not a big mystery because it is fully set out in the founding affidavit as well as in the submissions that were made to the public protector. The monies were spent on salaries because the campaign recognized early on that it would require full-time staff. They were spent on rallies and events. They were spent on meetings. They were spent on pre-election conference preparations, on public relations, on the printing of T-shirts, on the printing of pamphlets, and on the distribution of leaflets. They were also spent on traveling and accommodation. They were also spent on security. All of these features that I illustrate by reference to the papers are common cause, no dispute about them at all. How does the public protector then deal with these facts? We know that she produced a preliminary report at which she asked the president to comment, and the president gave her chapter and verse of how the money was paid, how the structure worked, and how the money was dispersed after it was received by the president. Her conclusions on this topic appear at page 02172. I just want to emphasize 4 of those conclusions. 02172, sorry, Justice 172, yes, on the case line. I just want to emphasize 4 of those conclusions, which will show that the public protector ignored the facts that were put before her. Whether that was deliberate or as a consequence of negligence is not for me to show, as long as the conclusion has no factual foundation. That suffices for the rationality inquiry. We go then to 7.21. What she concludes there was that the president exposed himself to a situation involving the risk of a conflict between his official responsibility and his private interests, or used his position to enrich himself and his son through the businesses owned by African Global, I can't remember what it stands for, is substantiated. The first part about it, the conflict of interest, there's just no factual foundation. What we know for a fact is that the monies that went into the CR17 campaign went into the campaign rather, but the campaign was an internal political campaign. There was simply no official responsibility involved at all. So the idea of a conflict between his official and private responsibilities simply does not arise. This was an internal political party campaign, and Mr. Ramaphosa, to the extent that he was participating in the CR17 campaign, did so as a member of the ANC, about which they all bear contractual obligations according to the Ramakatsa judgment. The second finding, enriching himself and his son through the businesses owned by AGO, but there's simply no basis for that finding at all. And she does not even seek to justify the finding by reference to anything that is on the record. Then in 7.22, she then says that it can safely be concluded that the campaign pledges were some form of sponsorship and they were a direct financial sponsorship and were therefore benefits of a material nature to President Ramaphosa. Now she makes 2 errors here. The first is that she ignores that if there were sponsorships, those were sponsorships to the campaign, and the campaign was a broad campaign. But she makes a second error, that these were direct financial sponsorship. As I have shown, there is not a cent that ever accrued to President Ramaphosa. On a net basis, President Ramaphosa paid the campaign 37.2 million rands of his own money. And the public protector nowhere explains where she comes to the conclusion that he received direct financial sponsorship. There's just no facts underpinning that conclusion at all. At 7.23, this is what she says. President Ramaphosa, as a presidential candidate for the ANC political party, received campaign donations. If we can just stop there. She concludes that the president received campaign contributions, but there are no facts whatsoever that the president ever received any campaign contributions. The campaign contributions went to the CR17 campaign. Not a cent went to President Ramaphosa. And it is on that basis that she then concludes in the balance of the sentence when she says, which then benefited him in his personal capacity. But the critical part is, what are the facts underpinning the conclusion that the president received campaign contributions? especially in the light of the uncontroverted, uncontestable facts that illustrate that the president was, to the contrary, a contributor to the campaign as opposed to a recipient of a financial donation. If we then turn to so that from paragraph 7.21, 7.22, 7.23, all of those findings are completely bereft of any evidence, of any facts. Page 02172, and yes, and the following, yes, yes, those are the three paragraphs. I have gone through each finding to illustrate that it contradicts the evidence, and the public protector does not bother to proffer the alternative basis of the facts on which she has made that conclusion. The following page, Justice Kithley, is at 02173. She again asserts a conclusion of fact with absolutely no basis. It is a total thumbsuck. She says that I have evidence which indicate that some of the money collected through the CR17 campaign trust account was also transferred into the Cyril Ramaphosa Foundation account, from where it was also transferred to other beneficiaries. Now let us stop here for a moment. The issue of the Cyril Ramaphosa Foundation was dealt with at length. She was told that the trust is a charitable trust. She was also told that the president is not a beneficiary to the trust. She was also told that the trust bears the president's name. But that is a far cry from the assertion that because monies have been paid through the Cyril Ramaphosa Foundation, therefore they constitute financial benefit accruing to him. They constitute financial benefit accruing to beneficiaries. But he is not a beneficiary. So that paragraph 7.24, just like 721 to 723, has no factual foundation whatsoever. The next conclusion is 725. She says here, President Ramaphosa, at the time of receipt of the donations. So she again assumes without any evidence that the president received donations. But nowhere does she ever put the president at a position where he receives any donation from anyone, because the president, in fact, did not receive any donation. And therefore concludes from that paragraph that at the time of the receipt of the donations, he was the deputy president, and therefore the duty of disclosure arose. But if the factual foundation is bad, the legal conclusion will equally be bad. At 7.26, she then asserts the conclusion, I therefore find President Ramaphosa's failure to disclose financial interest which accrued to him as a result of the donations was in violation. But two aspects there. The one is there was no financial interest that ever accrued to him. The second one is the donations that she is talking about were never financial donations that were received by President Ramaphosa. And so the conclusion, which is under the heading of findings in relation to the CR17 donations, is bereft of the facts. And if it is factually unfounded, it is irrational. And if it is irrational, it cannot stand as a matter of administrative law. So the conclusion in relation to this part of the debate is that the public protector misunderstood the facts. The facts were told to the public protector, but she overlooked them. The conclusions that she reached are entirely inconsistent with the facts. They are no more than a product of a thumbsuck. And that is why Mr. Trongov is right when he asserts that she was recklessly determined to find the president guilty of wrongdoing, no matter what the facts were. That would suffice to set aside this finding in its entirety, because it is a conflation and a confusion on the actual evidence. And just to conclude this part on the CR Foundation, it is Justice Kithley at 02902. Those are the facts explained to the public protector about what happened to the CR Foundation. Remember that she also raised a concern about the fact that monies were paid from that foundation to other beneficiaries. Yes, and at page 02357 and page 02368 are further illustrations of the response that was given by the President in relation to what the Public Protector knew. So quite early on, prior to the submissions being given, she in fact became aware of the structure of the campaign and what happened to the funds. I must conclude the point about the CR Foundation Trust. At page 02902, this is what appears. At paragraph 120, CR17 made the above-mentioned payments to CRF to reimburse it for the costs it had incurred in hosting meetings and travel and accommodation for the CR17 campaign. The campaign also made a donation of 5 million to CR Foundation to help fund CR Foundation's own communications campaign to publicize its work in the areas of education and enterprise development. CR17 did so because it believed that CRF's work reflected the ethos and the values of the CR17 campaign. So there was nothing hidden. She was told explicitly that the monies that went to the foundation were intended to help the foundation to publicize its work in the areas, and that's the crucial part about the charitable causes supported by the trust, in the areas of education and enterprise development. Remember that she also complains about the monies not only that were received by the foundation, but the monies that were paid by the foundation. But she does so as if she had not been told what happened to those monies. And yet, from paragraph 122 at 0292, and if you turn over the page to 02903, she is told expressly what those payments were for. The first point that is made in paragraph 122, the following payments were made to the foundation to reimburse them for costs incurred for the CR17. On 20 July 2017, and the amounts are stated there, costs incurred in setting up the Reattender Trust, costs incurred for travel and accommodation, printing costs, travel and accommodation costs, and travel and accommodation costs, which is at paragraph 122.5. And so there was utmost transparency in disclosing to the Public Protector what happened to the monies as soon as they hit the CR Foundation Trust and what transpired with the payments made out of the CR Foundation Trust. And she was also told that this was a charitable trust and that the President was not a beneficiary of the trust. So when she, despite all of that, nevertheless asserts the conclusion that by the mere payment of the monies to a trust that bears the President's name, that is somehow reflective of a benefit that was accruing to the President. Not only is she ignoring the evidence, but she is making conclusions that are in conflict with the evidence. So that there is not really much to be said about the conclusion that the President somehow withheld information that he should have disclosed, or alternatively the President was a beneficiary, directly or indirectly, of the funds that were received into the CR Foundation. The two instruments that she has relied upon, which is the Executive Ethics Code, together with the Parliamentary Code, are pretty much to the same effect. But they do not arise at all, their interpretation, because she simply got the facts wrong. And if she got the facts wrong, there is no way in which the court would bother with, if she had got the facts right, what the correct construction of the code would have been. It is sufficient to simply note that because she was foundationally mistaken on the facts, the legal debate as to the meaning of the code is a debate that simply does not arise. Because she was wrong in concluding that the President received monies, she was wrong in concluding that the President had financial benefits that accrued to him, she was wrong in concluding that the President received a direct campaign contribution. If she was wrong on all of those facts, the question of the meaning of the code is really a moot point. Could I move then to the next topic? The court will remember that I stated in my opening that I want to also show that in any event, she had no jurisdiction to investigate the CR17 campaign contributions generally. This current point. It is in the main heads from page 19 to page 27. And then in the response to the Amapungane submissions, it is from page 8 to page 15. So, yes. And the current point I'm about to move to is at page 25 of the main heads, which is the unlawfulness of the investigation. Perhaps.
Am I correct to understand your submissions, as you just made and as we continue, to also include the $500,000
Yes.
amount that was foreshadowed in the complaints?
Yes. Now, in relation to that $500,000, if the complaint was a duty of disclosure, then it is not disclosable. But if the complaint is you have misled Parliament in the way you have responded, then they are entitled to inquire into that question. Yes. So it includes it insofar as the duty of disclosure is concerned. But it excludes it if the President misled Parliament, because that is a separate inquiry altogether. Can I then move on to the question of the jurisdiction of the public protector? The court will recall that the jurisdiction point was canvassed right at the commencement of the proceedings. The case was made in the founding affidavit that the public protector did not have jurisdiction to investigate campaign donations generally. The public protector's justification for entering into the campaigns is threefold. I'll show the court precisely where it appears in the report. It is at page 02117 and page 02118. At 02117, she refers to the public protector case, which in paragraph 4 says that the public protector should not be limited to the issues that have been referred to her. That's the first justification. The second justification is in paragraph 5.1.12, where she says that the complaint of Mr. Maimane included money laundering. And then the third justification is section 6 sub 7 of the Public Protector Act. That we know not from the report itself, but from her answering affidavit, which is at page 02774 at paragraph 117, where she says, furthermore, section 6(7) of the Public Protector Act provides that I may investigate on my own initiative or on receipt of a complaint any alleged attempt to do anything which I may investigate under subsections 4 and 5. I will show to the court that none of those three justifications for what we have called is the extension of scope into the CR17 campaigns generally is justifiable. On the first argument, which is she is entitled to investigate under section 182 sub 1 sub A of the Constitution, because there she asserts that I have the power to investigate any conduct and not any complaint. From any complaint received, I identify the conduct to be investigated. If the court can turn to the section itself in the Constitution, it is section 182(1). The section says, the public protector has the power, as regulated by national legislation, A, to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice. Now, what is crucial there are the term state affairs and the other term public administration. So insofar as she anchors the trigger for the investigation in section 182(1)(a), she is mistaken because she has overlooked that those powers only exist if she is investigating the state or she is investigating public administration, not when she is investigating donations made to a political party or at least to members of a political party in the course of an internal party campaign. So that section is not a mandate for her to expand the investigation into the CR17 donations, particularly because those donations do not contain any public dimension. They are private donations made to a private entity and private individuals in the course of contesting for elections in a political party campaign. The next section that she relies on is section 6.7 of the Public Protector Act. I've asked copies of the Act to be made available to the court. I think copies were distributed during the tea adjournment. So, thank you, Judge President. She relies on section 6(7) of the Public Protector Act. The section says the public protector shall be competent to investigate on his or her own initiative or on receipt of a complaint any alleged attempt to do anything which she may investigate under subsections 4 or 5. So we know broadly that she is not bound by the complaint. She may initiate investigations. So to that extent, our learned friends are right. But the problem is that what she overlooks is what happens next, which is anything which he or she may investigate under subsections 4 or 5. So the jurisdictional power is restricted by what she can investigate under subsection 4 or 5. What can she investigate under section 6(4) and 5? If we then go to 4, what the public protector may investigate, in 4 it says the public protector shall be competent to investigate on his or her own initiative or on receipt of a complaint any alleged maladministration in connection with the affairs of government at any level. So it is state affairs again, which is the language of the Constitution. 2, abuse or unjustifiable exercise of power or unfair, capricious, discourteous, or other improper conduct or undue delay by a person performing a public function. So again, we are not in the realm of governmental powers or public functions. 3, improper or dishonest act or omission or offenses referred to in Part 1 to 2 or Section 17(2) of the Prevention and Combating of Corrupt Activities Act, but here is the qualification, with respect to public money. This is the act that she conflated with poker in the report. But what she forgot was that it is limited to public money. We know these were private funds. 4, improper or unlawful enrichment or receipt of any improper advantage or promise of such enrichment or advantage by any person as a result of an act or omission in the public administration or in connection with the affairs of government at any level or of a person performing a public function. So again, what we see there are the connecting factors: public administration, affairs of government, or a person performing a public function. And then the last one, act or omission by a person in the employ of government at any level or a person performing a public function which results in unlawful or improper prejudice to any other person. Again, the central point there is that there must be an employee of government or there must be a person performing a public function. So Section 6(4) is of no help to the public protector insofar as she relies upon it in reference to Section 6(7). Section 6(7) continues to refer to Section 6(5). 6(5) says, in addition to the powers referred to in subsection 4, the public protector shall, on his or her own initiative, or on receipt of a complaint, be competent to investigate. And then it lists all 4. I don't have to read them out, but the court can take notice that those are similar to the subcategories that are listed in section 6.4. What they have as a commonality is that the public protector's own initiative jurisdiction is only allowed in circumstances where the power in issue is public in its nature. She has no generic power to investigate all and sundry under the sun. Her powers are defined in the Constitution and further refined in the legislation. So the second justification, which is based on section 6.7 of the Public Protector Act, is simply unavailing. Then the third justification relates to the nature of the complaint. I should then explain why this is crucial. In section 3 of the Executive Members Ethics Act, the public protector is for the first time given powers of investigation outside the context of section 182 of the Constitution and outside the context of the Public Protector Act. She is now given additional powers. But those powers are then restricted. Under section 3, subsection 1 of the Executive Members Ethics Act, she can only investigate breaches of that code, or of the code passed pursuant to the Act, on receipt of a complaint. So the point ultimately on this score is the following. She's wrong. She has no powers under section 182 directly of the Constitution because that's restricted to public functions. No powers under section 6.7 because that too is restricted to the performance of public functions. She could have the powers to investigate under the Executive Members Ethics Act, but the trigger for that is that there should be an investigation. There should be a complaint. What do we know then about the complaints? These are summarized from page 0239 up to 0248 of the papers. It is in the founding affidavit where there is the fullest exposition of the nature of the complaint. There were 2 complaints, and there is a third complaint, but she expressly says that she did not rely on the anonymous complaint. She relied on the 2 complaints. The first complaint was by Mr. Maimane. The second complaint was by Mr. Shivambu. At page 0243 of the papers, we extrapolate directly the complaint by Mr. Shivambu, where he says at paragraph 105.2, I therefore lodge a formal complaint with the public protector to investigate, 1, whether the statement made by President Ramaphosa in the National Assembly on the 6th November 2018 that he saw a contract between his son's company and AGO is true and that a contract does exist. So again, this is the misleading of Parliament. And then paragraph 2, whether President Ramaphosa deliberately misled Parliament in violation of the Executive Ethics Code. So that really is the end of that complaint. So we can call that complaint 1. Complaint 2, which is the Mr. Maimane complaint, we would commend that the court has regard to the actual complaint, which is at page 0278 and page 0279. At 0278, Mr. Maimane gives a summary. But really what it boils down to is that I asked the President a question in Parliament, he lied in Parliament, and you must investigate whether or not he violated parliamentary rules by lying in Parliament. And then he goes on to the issue of money laundering. And this is now the third paragraph from the top at 0279, where he deals with the money laundering allegation. And I will illustrate why the public protector's conclusion here is utterly garbled. Mr. Maimane says that the nature of the payment, what payment? It is the 500,000 rands payment, passing through several intermediaries, does not accord with a straightforward donation. and therefore raises the suspicion of money laundering. So what is he saying? He is saying that I think that Mr. Watson has committed money laundering in relation to the way in which he paid the 500,000, because he did not pay this directly from his account, but indeed he used several intermediaries. What the court will not see in that complaint is a generic complaint about the CR17 donations. And so, Justice Blambo, when I initially, in answer to your question, said, yes, it arises in relation to lying to Parliament complaint, which is a valid complaint, but it does not arise in relation to the donations themselves. And so the point of the matter here is that there was never a complaint about the CR17 donations whatsoever. The jurisdictional trigger for the public protector's exercise of power under Section 3, subsection 1 of the Executive Members Ethics Act was simply never present. The public protector's attempt to tag the exercise of powers she did not have on the Executive Members Ethics Act, and specifically on the complaint by Mr. Maimane, can be dispensed by a simple analysis of the factual nature of the complaint. So only 2 points really ought to be emphasized here is that the only power she would have had under the Executive Members Ethics Code, read together with the Act, is upon the receipt of a complaint. She never received a complaint in relation to the CR17 campaign, and yet she went on a frolic of her own to inquire into the campaign, to subpoena people, to subpoena bank records, in circumstances where there was simply no authority to enter into the investigative space. There might, of course, be anxiety with the proposition, but there shouldn't be, because the public protector wields enormous powers, which correctly have been given to her by the Constitutional Court. But unless those powers have limits, as I have illustrated the nature of the contours and the outside limits of those powers, they are truly susceptible to an abuse. And that is why it is crucial that the court sets the limits as contained in the legislation and holds the public protector strictly to act within the confines of her authority. Her role, just like everybody else, must comport with the principle of legality. What she does not have is a free rein to investigate all and sundry under the sun. Her functions are limited by the legislation. So that, in summary then, on this point, she has no power under Section 182(1)(a), which they refer to in their answering affidavit. She has no power under Section 6(7) of the Public Protector Act. And she also has no power under the Executive Ethics Act, particularly Section 3, subsection 1 of that Act. And therefore, she should not have investigated the campaign donations at all. And that is an answer to one question, which is, what does one do about the balance of the investigation? One, if there is no power, there is no point in inquiring into whether or not these were funds that were known, these were funds that should have been disclosed, because no power existed. But it also dispenses with the Amapungane attack, because if this investigation was an unlawful investigation, well, that is the end of the debate. Pretty much the same as the argument that if there was no Audi, well, that will be the end of the debate. So it is quite plain then that the three justifications that she has given do not pass muster, and a finding should be made against her. That leaves me with one final point, which I will be very short on it, which is the court will recall that she made the three conclusions about what gave rise to the duty of disclosure. The first one was Section 96 of the Constitution, which is the provision that imposes a duty on members of cabinet not to put themselves in positions where there would be a conflict of interest. And then it was paragraph 2.1a to d of the Executive Ethics Code. And then the third one was paragraph 2.3 of the Executive Ethics Code. Simply to reiterate here that all of these interesting interpretative arguments will not arise if on the facts she got it wrong. And I have illustrated on all of the findings that were made about the disclosability of the CR campaign donations, that she got the facts wrong. But Section 96(1) simply does not arise because there is no position in which the President on the facts put himself in a conflicting situation between his interests and the interests of his office. This is unlike the Nkandla case. The court will recall in paragraphs 7 and 8 of the Nkandla case that the Chief Justice explains how a conflict of interest arises. Public funds were involved in building the President of the country a private house. There it was quite clear that there was a conflict of official versus personal interests, where the President was a prime beneficiary of public funds. There are no similar facts here at all. What is happening is that donors are putting money in an election campaign of an internal election. This is not even the other scenario that is sometimes adverted to but never fully developed, which is what happens to a campaign that is running for public office. We are not even dealing with public office here. So Section 96 sub 1 and 2 of the Constitution have no application whatsoever, because what is lacking is the presence of the official part of the two heads that Advocate Madonsela once referred to. Paragraphs 2.1 of the Executive Ethics Code also does not arise. For the same reason I have given, that we are not dealing with an official responsibility or an official position at all. And paragraph 2.3 of the Executive Ethics Code also does not arise, because we are not dealing with, again, this is a further elucidation of Section 96 of the Constitution, because we are again not dealing with an official position. So in the end, there was simply never a duty to disclose that was imposed on the President. The public protector's attempt at fashioning that duty upon the wrong finding of the facts should simply not be countenanced by this court. It would be one thing if the President went around asking for money, paid into his pocket, and then refused to accept that that somehow constitutes a financial contribution. All of the facts that she relies upon in coming to the conclusion that there were financial benefits accruing to him, that she was in receipt of donations, and that she received funds, all of those facts are wrong facts, and a court cannot draw a conclusion based on the wrong facts. So we would therefore submit with the greatest of respect that the question of disclosure should be decided against the public protector. It should be found that she had no authority to investigate the CR17 donations at all. It should also be found that the conclusions that she reaches at 721 to 726 of her findings are bereft of any facts. It should also be found that the provisions of Section 96 of the Constitution, paragraph 2.1 of the Executive Ethics Code, paragraph 2.3 of the Executive Ethics Code simply have no application, because they are distinguishable from a scenario where there is an official responsibility which is then conflated with a private interest. Justice Mlambo, those are the submissions. Yes,
thank you, President.
Thank you.
Who's arguing for the Speaker?
As the court pleases, my lord. I must apologize, Judge President, for arriving late at court this morning.
Yes.
I believe that my learned junior conveyed the reasons for my lateness.
She did.
Judge President and Judges Kitley and Tojane, before I go to the grounds of review, I would traverse some introductory areas in our application, or the Speaker's application. The Speaker's application appears at 02656 up to 02672. The replying affidavit appears at 02352 to 02358. The Speaker seeks a review and setting aside of the Public Protector's remedial action which implicates the Speaker at paragraphs 8.1.1, 8.1.2, 8.1.3, 9.1, 9.2, and 9.3 of the report of the Public Protector, and those remedial action items I've referred to appear at 02-174, and the monitoring remedial action appears at 02175, and remedial action 8.1.2 has to be read with the Public Protector's observations at paragraphs 6.1 to 6.6 of the report, and those appear at 02-170, going over to the next page. The remedial action proposed by the Speaker in regard to 8.1.1 can be broken into about 4 parts. Firstly, the Public Protector specifically prescribes the Code of Ethical Conduct and Disclosure as the instrument that must be utilized in order to bring disciplinary action against the President. The code that is being prescribed applies to members and permanent council members. And thirdly, she prescribes that the referral must be to the Joint Committee on Ethics and Members' Interests. And she prescribes that paragraph 10 of the code is of application. In regard to 8.1.2, the Public Protector directs that issues that she comments on at paragraphs 6.1 to 6.6 must be subjected to possible review and amendment. At 8.1.3, she directs that the Speaker must demand publication of all donations received by the President, because secondly, as he was the then Deputy President, he is bound to declare into the members' registrable interests register. It is convenient, Judge President, to deal first with the role of the Speaker in our Constitution. The code that is referred to and the rules of Parliament derive from Section 57 of the Constitution, and Rule 3 of the National Assembly states as follows, and I believe that we have uploaded the excerpts of the rules, Judge President. Sub-Rule 1 reads as follows. The rules of the National Assembly are adopted by a resolution of the House in accordance with Section 57 of the Constitution. So that is the power of Parliament to fashion these rules. Sub 2, the rules remain in force until amended or repealed. And 3, the rules must be strictly adhered to by members. Now, the role of the Speaker herself is set out in Rule 26. And it is headed General Authority and Responsibility of the Speaker. And it is to exercise it prescribes that in exercising the authority of the Speaker as provided for in the Constitution and legislation and the rules of Parliament, the Speaker must do the following as set out in paragraphs A, B, and C. And paragraph B prescribes in particular that she must ensure that parties represented in the National Assembly participate fully in the proceedings of the Assembly and its committees and forums, and facilitate public involvement in the process of the Assembly in accordance with Section 57 and 59 of the Constitution. As the court is.
An observation.
Yes, my lord.
I think these are all preliminary facts for which there's no contestation.
Yes.
Would you feel offended if I requested you to tell us why your client takes issue with what the public protector did? In the light of everything that you want to take us through.
Yes, my lord.
You feel offended? You want to go through that?
My lord, I will proceed, Judge President, to the grounds for review which appear in our heads at 04-88 going forward.
I'm sorry, but we all are dressed up to hear what the contestation is.
My lord, the preliminary points will become relevant in due course, but the court has read the rules, has read the codes, because the public protector and the EFF will contend when they argue that the president does not fall outside of the jurisdiction of the parliamentary processes or the jurisdiction of the speaker. And we will suggest that those preliminary provisions, legislative and otherwise, were to address the issue. But, Judge President, at paragraph 34 of our heads, we start by indicating that the courts of the country have already stated that the public protector's exercise of her core powers and functions is reviewable on the basis of the principle of legality that stems from the founding constitutional values. But the courts have also dealt with the question as to what constitutes appropriate remedy. So our submission is that all the remedial action that the public protector has prescribed is inappropriate. And we deal with that from paragraph 37. And at paragraph 38, it is our submission that what the Constitutional Court held in EFF versus the Speaker at paragraph 71 under footnote 13 holds in respect of what the public protector has done in this matter. There it was held at paragraph E and F of paragraph 71 that appropriate means nothing less than effective, suitable, proper, or fitting to redress or undo the prejudice, impropriety, unlawful enrichment, or corruption in a particular case, and also only when it is appropriate and practicable to effectively remedy or undo the complaint would a legally binding remedial action be taken. It is our submission, Judge President, that paragraph 8.1.1 of the remedial action is inappropriate, and at paragraph 40, we refer to a case at footnote 14, which is my vote counts versus the Speaker, and the excerpt reads as follows. The applicant wants information on the private funding of political parties to be made available in a manner preferred by it. It prefers that the legislation should require the disclosure of the information as a matter of continuous course rather than once off upon request. And then 5 lines down on this page 04-90, the court says it is for Parliament to make legislative choices as long as they are rational and otherwise constitutionally compliant. And further down, the next paragraph, despite its protestation to the contrary, what the applicant wants is but a thinly veiled attempt at prescribing to Parliament to legislate in a particular manner. And the last sentence, that attempt impermissibly trenches on Parliament's terrain, and that is prescribed by the doctrine of separation of powers. So in this paragraph, my Lord, all our grounds for review are covered, including the encroachment of into the powers that reside within the ambit of the legislature, in particular the Speaker. And we will submit as we go forward also that it is not for the public protector or for the EFF to then say the dictation of the public protector is appropriate or proper in the circumstances.
So can I ask you a question? You don't take issue with the finding, you're not entering into that terrain of this dispute.
No, we are not,
Yes.
Justice
Do you
Kitty.
dispute the public protector's power to make that finding? In other words, her finding that there was a breach,
Yes.
which forms part of, it's a finding preceding the remedial action.
Yes.
But it has relevance to the remedial action because she says what steps must then be taken to deal with that. Is your contention that her very finding of a breach encroaches on Parliament's power to determine for itself whether there have been breaches of its code, or is it more nuanced than that?
It is more nuanced than that, Justice Kitley, because the Speaker is only brought in these proceedings in order to bring into action remedial action that the Speaker prescribes. And although in our papers we did indicate that campaign funds do not constitute this registrable interests, we've left that to the President to argue, and Mr. Trengove has dealt with that, and we will not deal with that. And The code that the public protector puts the president under this jurisdiction is specifically paragraph 10, and to a certain extent, the representatives for the president have dealt with that it only applies to members. And the court would have seen, and we will give references, that both the public protector and the EFF submit that paragraph 10.1.2 of the code, as it appears at 02-703, brings the president under the ambit of the Speaker. Paragraph 10.1.2 reads as follows: a former member breaches this code if the former member contravenes clause 8.2 of the code. And if the court goes back to paragraph 8.2 at 02-695, the heading speaks for itself. It's members' facilities, and I might as well read sub 1 and sub 2 together. A member must avoid any abuse or improper use of members' facilities or any benefit provided to members by Parliament, and strictly observe and adhere to the administrative rules that apply to such facilities or benefits. And that's to existing members of Parliament. And then sub 2 reads, a former member must avoid any abuse or improper use of members' facilities or any benefit provided to the former member by Parliament, and strictly observe and adhere to the administrative rules that apply to such facilities or benefits. So that submission by the two respondents does not assist them because this paragraph deals with members who are exiting Parliament. They have ceased to be members, and but they continue to use unjustifiably and without proper permission the facilities that are provided to existing members. So we submit that the submissions by the EFF and the public protector in regard to whether the Speaker has jurisdiction over former members this paragraph does not assist them. At paragraph 43, we deal with that submission that the Speaker's powers have not been usurped. And for ease of reference as to where the two respondents make these submissions, if I may just indicate to the court, in regard to the public protector, it is specifically dealt in several paragraphs, including page 04-167, paragraph 156, where it is stated that it is unfathomable to contend that the Joint Committee would not be in a position to make a finding in the 6th Parliament over matters concerning former members in a previous Parliament. And the EFF says the same at paragraph 04-222, paragraph 16.1.9. And it is stated there that the Speaker's suggestion that Parliament has no ability to discipline the President because the conduct occurred during the 5th Parliament demonstrates the reason why Amabungane's constitutional challenge must succeed. There are several other references in the answering affidavit of the Public Protector and the EFF where there's this refrain, and there is no other submission beyond that. If the court so wishes, we may provide all the references where the same contention is made. Now, just to hasten a bit, those contentions that paragraph 10.1.2 of the code applies, and that the Amabungane's application should succeed, almost amounts to an admission by the two respondents that in terms of the framework within which the public protector referred the matter to the speaker has no jurisdiction. And they say, nevertheless, notwithstanding, in the interest of holding the president accountable, the speaker should and could have done something. And then the EFF is saying basically, if the code excludes former members, then the Amabungane application must succeed, and we will not traverse that because my learned friend, Mr. Trengove, has dealt with that aspect extensively. And in regard to paragraph 8.1.2, which is to be read, 8.1.2 of the report, which is to be read with paragraph 6 of the report, our submission is that the rules provide adequate mechanisms for doing exactly what the public protector orders the speaker to do. And therefore, the remedial action is inappropriate, and it seeks to usurp the powers of the speaker. The rules are clear, in particular, Rule 4, which deals with the suspension of supplementing of rules. So if the public protector's observations in paragraph 6 are of concern to her as to the manner in which members respond to follow-up questions, the rules provide for appropriate amendments to be made. And Rule 6 deals with unforeseen eventualities. If something was unforeseen, the speaker may give a ruling or frame a rule in respect of any eventuality for which these rules or orders of the House do not provide. And the rule is to be read as a whole. And then Rule 9 is about conventions and practices. Conventions, it reads, sub 1, conventions and practices relating to the business of the House and its committees and other forums are established by agreement amongst political parties and parliamentary office bearers and may be varied by agreement amongst them and reviewed from time to time as decided by the Rules Committee. So our submission, Judge President and the Justices, is that this remedial action is inappropriate. It is superfluous because the rules already provide for these processes. And most significantly, the submission is that South Africa's parliament is a multi-party parliament. It's a multi-party democracy. All these political parties are there to assert their rights as set out in these rules if anything does not go in accordance with their expectations or what they believe the rules would be. In fact, the President himself, if he's aggrieved or the ANC is aggrieved by the way in which the question and answer and follow-up questions and answers were dealt with on that particular day, the rules provide for a mechanism to have dealt with it without the public protector coming in to deal with the issue in the manner that she does. And then 8.1.3 is dealt with in paragraph 49, and at paragraph 50 we submit that paragraph 8.1.3 of the report is also inappropriate. The Executive Ethics Code, as well as the Code of Ethical Conduct and Disclosure, sets out a list of the kind of financial interests that must be disclosed and are registrable. And we make the same point that has already been made, that campaign funding in the context of this matter is not listed in the code. And in this regard, the public protector responds that clause 9 of the Code of Ethical Conduct and Disclosure provides that, quote, any other benefit of a material nature are registrable interests. That has been dealt with, but the reference is page 04-148 to 04-149, paragraph 94. And this assertion is specifically contained in paragraph 9.3.7 of the code. And in regard to the question of monitoring remedies that are prescribed, we deal with that at paragraph 73 to 76. And we quote an extract from SABC versus DA, in particular at paragraph 52, where in the middle of that excerpt, it is stated that the public protector may determine the remedy and direct the implementation. What that means does not mean monitoring. And what implementation means in this context was also dealt with in Minister of Home Affairs versus Public Protector, paragraph 46. If I may read the paragraph. And our submission is that it elaborates on the meaning of implementation as directing appropriate remedial steps to be taken by the functionary against whom the public protector has ordered remedial action. At paragraph 46, the second line reads, halfway, let me read the second sentence as a whole. For the rest, her jurisdiction is extremely wide and her mandate is clear. She must seek out and effect the rectification of maladministration through directing appropriate remedial steps so as to ensure good governance. So this does not empower the public protector to impose supervisory orders or structural interdicts or monitoring mechanisms as she has ordered in this matter. Paragraph 74, although the public protector may direct implementation, what is clear is that the public protector does not possess monitoring powers over the National Assembly. In fact, it is the other way around. The public protector is accountable to Parliament, and by imposing this kind of remedial action, she is reversing the processes and ordering the Parliament to be accountable to her. We have added in our list of authorities a case of Mwelase and others versus Director General for the Department of Rural Development, and we specifically refer to paragraphs 51 and 53. Our submission in regard to those paragraphs is that supervisory powers, monitoring powers are reserved for egregious conduct on the party that the public protector has been investigating. So these cases are of equal application in regard to the public protector, that she has encroached into the powers of the legislature, in particular the Speaker. And then we make our concluding paragraphs at 77 and 78, and we ask for costs, but if the Judge President and the Justices don't have any questions, may I confer with my Leonard Jr. for a second?
The Protector has directed the Speaker to order the President to disclose the people who make donations to the campaign. I just want to know whether, with other cabinet members, are they also obliged to disclose monies that are paid to third parties, which are then used to fund the campaign? What I want to know is,
yeah.
is this instruction specific to the President only, or has it happened before that a member of cabinet should be obliged to disclose monies that are paid to third parties, not directly to that politician, but to a third party, and the third party use the money to fund a campaign?
There's no instance that we are aware of. What we submit is will be to align ourselves with the President's submissions, which distinguish between a public representative receiving a benefit during the course of performing their function as a public representative, as distinct to when they are involved in party political activities, and the Speaker may not, in those instances, demand that they disclose who funded them to conduct those activities. Just to emphasize that the code does not apply to former members, it is clear what penalties are to be meted out if a member has contravened or breached the code. But there are no penalties that correspond to former members. So our submission is that on the reading of the code, as a whole, the source of the rules and the applicable codes, there is no way in which it may be suggested that the Speaker has jurisdiction over the President in circumstances where the remedial action specifically prescribes the mechanism that the Speaker must utilize. And the Speaker was therefore entitled to come to this court and say, on what has been prescribed to me to do, I am unable to do it. And because it is common cause, but that at the time that this event took place, the President had ceased to be a member of the House from the moment that he was sworn in as President of the country.
Takes the position that your client was free to ignore what she sent to you. Am I correct?
She does, Judge President.
Does that still entitle you to come here?
It still does, my Lord, if the Public Protector's remedy is binding, and otherwise there would have been another application to court to compel the Public Protector to act if the Public Protector believed that the Speaker was misinterpreting the ambit of her powers, or whether she did have jurisdiction or not. But so it is contested. If it is contested, it will lead to further litigation. But we are here because we have been ordered to implement paragraph 10 of the code.
Well, how is her remedial action to your client binding if she says you are free to ignore
it? If the Public Protector says the Speaker could easily have written back to the Public Protector and said, yes, I don't have jurisdiction, Mr. Trencove made that point, and properly so, that had the Speaker had the Public Protector contacted the Speaker to say, I contemplate the following remedial action. May I hear you before I release my final report? Then the Speaker would have said, I don't have jurisdiction. Then that would indeed have been the end of the issue if the Public Protector had accepted that. But if the Public Protector had not accepted that answer coming from the Speaker, there would have been some application of one or another kind to compel the Speaker to act in accordance to remedial action.
Could I just come in there, Mr. Velindi? Isn't there another answer as well? And this is that when the NDPP wrote to the Public Protector to ask for clarity and to suggest that if she meant something other than what was literally stated in her remedial action, she should then simply amend her report. And her response to that was, it's not open to me to amend the report. So if her view now might be that you're not bound by it, it's not for her to say you're not bound. she herself has taken the view that only a court of law can change that outcome.
Indeed, Justice Kitcliffe, she has already taken that stance with one of the respondents. The chances are that she would have adopted the same. But we may also refer to our reply to the Speaker's replying affidavit at 021345, paragraph 7, where the Speaker states, the Speaker's decision to institute these review proceedings is in essence a measure of last resort. I say this because the Speaker's office has previously engaged the Office of the Public Protector regarding its concerns in the manner in which the Public Protector's remedial action seeks to prescribe to it what to do in fulfilling its constitutional obligations. And that correspondence is attached to the founding affidavit as one of
That was paragraph
7, my lord, my lady,
of the answering
of the replying affidavit.
Yeah.
So that correspondence is already there. So experience has indicated that any approach to the Speaker in any way, there wouldn't have been any approach because the Speaker was confronted with a final report. But previous experience already has indicated that interaction with the Public Protector on the modification of her reports or remedial action has not been most welcome.
Thank you, Advocate Malindi. We are going to adjourn and come back at 14:07. Adjourn.
by the NDPP of that fact, and the NDPP then obviously will do a job. The notion that the public protector is some super sheriff that can swing into the NPA and direct the NDPP to conduct a particular investigation and then to report back on her on that investigation is simply not contemplated in 6.4 C1, or for that matter, in the enabling constitutional power.
So what do you say it means? Because the relevant phrase says to bring the matter to the notice of the relevant authority. What does that mean? Just please take note. I found the following.
The relevant authority responsible for prosecutions in 641C.
Yes.
It's to say to her, so in this case she would notify the NDPP of a report.
Yeah.
She would bring her attention to the particular provisions which she says record her suspicion of money laundering, and she would inform the NDPP that under 6.4C1 she is now notifying the NDPP of her suspicion. That's all she can do under 6.4C1. Now,
so she can't say, once you've investigated, report back to me.
no. For a number of reasons. One, that's not what 6.4C1 permits. It doesn't say she can do that. And two, that would infringe upon prosecutorial and investigative independence. We then go on to the main arguments by the EFF. So its main arguments are these, that the public protector may in the
Sorry, Mr. Brainers, presumably the NDPPs are responsible to Parliament. They must account to Parliament.
Oh, yes.
Yes.
Oh, no, they must obviously account in terms of their own act
Yeah.
and their own constitutional duties.
But your point is they're not constitutionally
Accountable.
to her, and that would be contrary to the constitutional scheme.
Yes. So we say there are really four main points that we need to address that are raised by the EFF. The first is they say that the public protector may, in the exercise of her powers, issue remedial action that constrains the exercise of powers vesting in other organs of state. It argues that the NDPP's objection to the remedial action incorrectly assumes that she requires specific steps to be taken and has predetermined how they should be taken. Third, they say they rely on SABC versus the DA to say that the NDPP can't second guess the public protector. And then lastly, they say, well, the remedial action is not inconsistent with the doctrine of separation of powers. Can we deal with the power to constrain first? And here the EFF gives two examples illustrating why its submission that the public protector may order remedial action constraining the powers of another organ of state. And they say this is why it's struck. They say, one, the public protector may order the president to appoint a commission of inquiry conducted by a judge selected by the Chief Justice into allegations of misconduct by the president, even though it is the president and not the public protector who has the constitutional power to appoint commissioners of inquiry. And the second example they give is they say the president has the power to appoint the NDPP may be curtailed if the NDPP may have to make a decision whether to prosecute the president. Now, the first point we make, the answer to the first point, that's the president case, is this. In that judgment, we first say that's distinguishable. It's quite different. And the question there was it appropriate to order the president to appoint a commission and then to direct the Chief Justice to appoint the judge to head up that commission? The court there found it was because of the conflict of interest in that case, because the president himself was the subject matter, or would be the subject matter, of the commission, and it was important that the commission and the judge who heads up the commission is seen that they both seem to be independent, and so in that case that was appropriate. Well, that simply doesn't apply here, because this is not a case where there's any suggestion that there's a conflict that arises with the NDPP. There's no, the facts are just completely different. The presidential power to appoint the NDPP argument, well, we must say we find that argument unintelligible. We don't quite understand what it means, because this is not a case about the power to appoint an NDPP. This is a case about the statutory powers of the public protector against the NDPP. Then the EFF submits that, well, what happened here was she did no more, it's the point raised earlier, she did no more than attempt to ensure that the NDPP investigates and prosecutes the President if his conduct is worthy of criminal sanction. So they say, well, she needed to do no more than just apply her mind and do what she normally does. And in its argument at paragraph 16, what the EFF submits is that the NDPP has misinterpreted the words of the remedial directives. Well, that contention isn't supported by the words of the directive. Those words must be given their plain meaning in context. And we say, we've already dealt with this point, the meaning is clear. But it's also not consistent, and we get to this later, with the conduct of the public protector after she orders the remedial action. We'll get to that in a moment. Then they their submission on the SABC, it submits that relying on that case, the NDPP can't second guess the public protector. Well, in that case, what happened was, as the court will recall, the public protector found pervasive maladministration at the SABC and made remedial orders. They were against the minister and against the board. What the board did was, it went to Mkhwebane attorneys and asked them to review the report. And the Mkhwebane attorneys said, well, they find that the report consists of untruths and inaccuracies, and that the SABC was not obliged to comply with the remedial action ordered there. And I'm not going to run through it, but it included, for example, disciplining Mr. Motswaneng, when in fact after they then appointed him. Now there, what the court said was, you can't run a parallel process. You can't sort of ask yourself, well, I now have the report, let me set up some process where I can review it and I can assess whether I should comply or not. That you can't do. If you're unhappy with the report, well, you must challenge it in court, have it set aside on the review. But that's not the case here at all. The NDPP isn't saying, she hasn't set up some parallel process to assess the report. What she did was first seek clarification, and when that wasn't on, she joined as a respondent in support of the review against 8.2 and 9.4, the two orders that affect her. So this is, in SABC and BA, is distinguishable. Then they say, well, they raise the separation of powers submission. We say, well, it doesn't apply between the public protector and the NDPP. The principle of separation of powers recognizes the functional independence of different branches of government. This is not so at all. I mean, we've got the Constitution providing for the statutory regulation of the public protector's powers. There is a statutory power. It applies to us. What the court has to do is ask itself whether that power permits the public protector to do more than it permits in its plain wording. The main arguments by the public protector. She argues that the remedial directives are not directives to investigate or monitor. The NDPP may ignore her directives because she has a discretion to decide whether to investigate or not, provided that decision is exercised lawfully and for a legitimate purpose. And in effect, the directives constitute a referral as contemplated by 6.4c1. We say, her letter of 7 August 2019 makes it clear that she did not intend merely to notify the NDPP of her opinion that there was evidence of money laundering. You will recall that in that letter, the NDPP asks for clarification. And the letter coming back, which is at page 1176. That's a letter of, well, it's a letter of, sorry, I beg your pardon, it's letter 1179, so it's the letter of 7 August 2019. And at paragraph 10, what Mr. Mhlongo, the Senior Manager, Legal Services, on behalf of the Public Protector, says is this: the case law is clear that the Public Protector can direct organs of state to take certain steps and even direct how those steps should be taken. Although the Public Protector cannot dictate to the NDPP how the investigation must unfold, the NDPP must nevertheless submit an implementation plan as recorded in the report. So that letter makes it clear that she considered that she had supervisory powers over the investigation. And then if one looks at the exchange between the President's attorneys and the Public Protector's attorneys, and that's at 444 of the papers. At first, what the Public Protector said was that she would not agree to staying the remedial orders against the NDPP. And then reluctantly she agreed that, because the President then wrote again, President's attorneys wrote, said, well, why not? There's this review. And she reluctantly agreed, but she made it clear that she considered that the NDPP was bound to follow her remedial, to comply with her remedial orders. We submit this, that the arguments by the Public Protector are inconsistent with the plain wording of the remedial directives in 8.2 and 9.4 of her report. They are inconsistent with her letter to the President, and I beg your pardon, it's at 02439 and 02440 and 02439. They're inconsistent with those letters where she refuses to agree to stay the remedial action, but then later reluctantly does. And we say they are inconsistent with her letter of 7 August, which we've referred the court to. And finally, we say that if she meant, which the NDPP asked her, if she meant to refer simply under 64C1 her suspicion of money laundering to the NDPP for investigation by the NDPP under the Authorizing Act and the Constitution, well then what she did here demonstrates that she does not understand how to formulate a referral to the NDPP under 64C1 of the Public Protector Act, because those directives simply do not read like a referral under 64C1. Yes, it does. We set that out in our heads at if you read our heads at paragraph yes, yes, the we set it out at paragraph 39. And also at just find a few. It's at paragraph 31 of our heads. And what we say there is that one of the incidental functions of the NPA is the power of investigation. And then you've got Proclamation 20, which by the President of March 2019, which requires the investigation of statutory offences. And Clause 2 establishes a directorate in respect of statutory offences under POCA. And one of the purposes of POCA is to make money laundering an offence. So the NPA does have the power to investigate it. And, my Lord, the NDPP, as we understand it, under her powers under the Act, she does have the power to direct investigation. So investigations are done by the investigating director. The NDPP has the power to supervise and direct the investigating director. Those are submissions.
Mr. Stefane?
Judge President, Justice Matujana, and Justice Quigley. I'll try and confine my submissions to the 2 hours we were given, because we make the following submissions. One is that if you read the relevant statutes properly, and that is first the Constitution, Section 1822 of the Constitution, read together with Section 6(4) of the Public Protector Act, there is absolutely no doubt that the Public Protector has jurisdiction to investigate matters that are the subject of this case or her report. 2, if one has regard to the precise answer given by the President in Parliament, you don't have to do any fancy footwork about it. You honestly look at what he was asked and what he said. Your answer is that what he said, by his own admission, was not the answer he should have given. It was wrong. He misled Parliament. We'll get to that because the test is put differently by our learned friends, that you don't know his intention and therefore you can't know that he intended to mislead Parliament. The third submission we will make, we will contend that the facts of this case, without any doubt, reveal that the President was given more than one opportunity to be heard. And so the IOD point that is raised is incorrect. To the extent that, and we've said this it's in the affidavit, that there may have been reference to a wrong code, what this court will have to deal with, because we don't deny that there may have been at some point of the report reference to the wrong code, right? What this court must ask itself is the materiality of that error. I don't agree with Mr. Trengov that it was extraordinary. No lawyer would do that. It's hyperbole. Truly, it's an error of that. If you look elsewhere in the report, you will find that there is proper reference to the right code. And so that error, even if it's there, on the case law that we know about materiality and that we have to consider substance and not form, we want to submit to this court that that error, that reference area, makes no difference to the outcome, and therefore it's not material, because it's not a reliance on it. If you look at all of them, you will see that, I know that there was some distinction about deliberate or willful. We will submit that, looked at properly, it doesn't matter which code she quoted. Deliberate or willful misleading of Parliament happened. Ms. Karachi will deal with remedial action at the end. But we will submit that it is appropriate. The remedial action that's in the report was appropriate. The last point, Mr. Mkhwebane went to great lengths on the jurisdiction point. relying selectively on 182, fancifully avoiding the meaning, the real meaning of the word state affairs in the Constitution, because he knows that state as a notion, and our constitutional drafters show it, state affairs and public administration are different. And I will explain to the extent that he wants to argue that state is not, the word state does not mean what the subject of this investigation was. I wish to point out to the court that that, as a legal definition of what the state is, of course it takes the source of that definition is not just law, it's political science as to what the state is. And we submit that a proper interpretation of state affairs, as set out in 182, means that the public protector could investigate a matter of this nature. Let me start, because right in this court, a couple of minutes ago, a public protector, Chapter 9 institution, was called a rogue. In the court, was called a rogue, without justification. This case is about two most important constitutional beings in this country, both of whom require respect. What we're concerned about is whether in their conduct, both of them, they comply with the constitutional and statutory obligations, their constitutional and statutory obligations. And if in any way the public protector does not comply with those, of course I would be the first to agree that she has not acted properly. And the case is the same with the president, and it doesn't matter which president. Now, to the extent that the grounds of review on this application are based primarily on this contention of jurisdiction, Judge President, you will see that our learned friend, this court, and the Judge President present here today in particular, has pronounced on a number of cases about the jurisdiction of the public protector. And there are many cases. And it is no surprise that our learned friends who know those authorities don't rely on them because it's inconvenient. So, first, I will set out what's in the Constitution and the Act. Second, because our learned friends skillfully avoid going to what this court, the SCA and the Concord, has said about the office of the public protector, because it was a different one, but the rules should be the same. What our courts have said about all of the elements of this case. Third, because we're talking about the president too, I will set out briefly the constitutional provisions that govern the functions and conduct of the president and his cabinet. Fourth, I will make particular reference to the comments of the Constitutional Court on the constitutional standard to which the president must be held. Fifth, I will then set out, to the extent that we've been told endlessly since this morning, there is no factual basis for what the public protector said. I will set out briefly, without all of the facts that we've set out in the heads or in the affidavits, what the essential facts are and what standard the public protector has to meet in order to fall within her statutory and constitutional provisions. Then I will show, lastly, that the grounds that have been raised on behalf of the president keep shifting. And I will go to the heads of argument and the affidavit to demonstrate that on the jurisdiction point alone, we're not being told a consistent argument. Let me start with saying Section 181(2) of the Constitution is where we should start. It starts with these institutions, like the public protector. says these institutions are independent and subject only to the Constitution and the law. And they must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. But the most important one, for present purposes, that gives the public protector power to engage with other organs of state. It says, that's 1813, other organs of state through legislative and other measures must assist and protect these institutions, that's the Chapter 9 institutions, to ensure the independence, impartiality, dignity, and effectiveness of those institutions. 181 provides that no person or organ of state may interfere with the functioning. But the most important one, because this is the one about which my learned friends and I part ways, how we interpret it. Section 182 sets out the functions. And may I say right at the outset that if you look at what the Public Protector Act says about those functions and those powers, it says they are additional to what the powers that she or he is given under Section 182. And it says, the Public Protector has the power as regulated by national legislation to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice, to report on that conduct, and lastly, to take appropriate remedial action. This section goes further to provide, the section of the Public Protector, to say the additional powers and functions prescribed by national legislation. I'm adding because in the analysis of our learned friends of the Public Protector Act, you would think we should forget about the functions to which they are an addition, which are in the Constitution, because they're trying to avoid the broadness of the word state affairs. Let me hold it right there about this point, because I don't want to come back to it. Mr. Ngogaitebo makes a particular point here. He says the matter was not a matter of public administration. Therefore, the Public Protector has no authority or jurisdiction. With respect, he avoids the word state affairs. For the definition of state I'm going to give, and it's not inconsistent with the legal definition, by the way. He says there is nothing in CR17 that relates to matters of the state. Well, in fact, in their heads of argument, can I just make reference to a point they make where they say it should be the end of the matter? He put three justifications why the Public Protector said she has jurisdiction. She forgot this one. He forgot this one that they make in their heads of argument. In the electronic version that I don't understand, but it's called the page 0426. But the paragraph in their heads is 58. He forgot this big point of theirs in their heads, paragraph 58. They say, the Public Protector does not suggest that the funding of a campaign for election of a group of ANC members to the National Executive Committee of the ANC is conduct, and then quote, in state affairs or in the public administration in any sphere of government, close quote, as contemplated in section 1821A of the Constitution. We respectfully submit that this should be the end of the inquiry. They say nowhere, in belligerent terms. Well, I submit that the converse should be right, if I can demonstrate that she does. because they say it with such certainty that nowhere does she do this. Well, I shall refer to volume 1 and take this quote to the paragraph where the public protector says this, to demonstrate that when they say nowhere, because they're trying to say, even if she is right that the state is broader, but she doesn't make that point at all. I will read this paragraph. It's page 02-96. This is volume 1. Paragraph 3.3.13. This is the public protector saying, amongst other things.
Just slow down, Advocate.
Okay.
Can you say what paragraph is it?
3.3.13. I'm just dealing with the fact that
Right
they...
at the bottom of the page.
Yes, right at the bottom. I'm just dealing with the fact that they belligerently say no way, and if she did, because she doesn't say this should be the end of the matter, well, this should be the end of their argument, because we've now found where she says it. She says, the conduct of President Ramaphosa amounts to conduct in state affairs, and therefore the matter falls within the ambit of the public protector's mandate. That should be the end of the matter on that score, because she does. But to the extent that an argument has been made that state affairs does not include CR17 funding of a deputy president. Now, of course, if you look at the state in a shallow way, as lawyers do, we say the state is the judiciary, the state is the legislature, and the state is the executive, those three. And that's where lawyers end when they define the state. But those three components of the state themselves, and that is why the distinction is drawn in the Constitution, those very three components of the state that lawyers quote as the only definition of the state are actually summaries of 4 components of the state in political science, of what the state is. And the Constitution separates that because it recognizes, here are the 4 components of the state that Mr. Ngogaitobi pretends do not exist. First, its population. 2, its territory. 3, its sovereignty. 4, let me go to it. There are not 3 though. That's territory.
What was the second one?
Territory.
Sorry. Really,
Well,
this is
now that we're talking about
socioeconomic
donations,
state.
yeah. But I'm making this because there's a dishonest way of looking at the state, or a shallow way of looking at the state, and it's inconsistent with the distinction the Constitution makes for us. And I'm raising it.
That, Mr. Tikakane?
Where?
Where do you find that?
We find
Or you just say that's your gloss of the Constitution in
absolutely
in terms. That's
absolutely.
Your gloss. Thank you.
That's what the
Thought it
state.
might be in the preamble, or that gives greater
absolutely.
direction in this regard.
But because we were told that because we can't say that she was investigating the judiciary, the executive, or the all right, the JP is asking me to go to those 4 that I forget. Yes. There are 4. In fact, the most important one is the one I forgot, about which they seem to think that is the state. It's territory, it's the population, it's government, and it's sovereignty. Now, the 3 components that we talk about as lawyers, which is the three branches of government, are all a sum total of these four components of the state. And therefore, when the Constitution deals with the state affairs, it is broader than public administration, and it draws that distinction. We submit that if you objectively look at what are we dealing with here as the facts, it's a deputy president, the deputy president of the country and the ruling party, seeking to become president of his party. Not to end there, it's not a private matter, in order to become president of the state. That's what it is. And if you understand the state as I've explained, you cannot draw that distinction. In fact, Section 96 of the Constitution acknowledges this, because it acknowledges that people can act in their private space, but when they occupy particular positions in the executive, they may open themselves to the risk, even though they are not performing functions that are official, to the risk of a conflict between their private and public matters. The point I want to make in that one is that the understanding that CR17 was beyond the matters of the state that can be investigated by the public protector is narrow, self-serving, and incorrect. It's not a proper understanding of the state. And because the answer will be that the state is those three branches, that itself is a misunderstanding by lawyers of the political science of the state and what it is. But that summary is a summary of what the state is. Therefore, we submit that the jurisdiction point is wrong. Let me move to the Act itself, which then puts other additional points. The Public Protector Act is the legislation contemplated in Section 1822 of the Constitution. For present purposes, Section 64A provides for the additional functions and powers of the Public Protector. And it provides, it says, may I quote it, "The Public Protector shall be competent to investigate on his or her own initiative or on receipt of a complaint any alleged maladministration in connection with the affairs of government at any level." Now, of course, that is an addition to what we now know she can also do, matters that are within the state. And our Constitutional Court, fortunately, and this court in particular, has made comments about the functions and powers of the Public Protector previously. May have been a different Public Protector, a different administration, but the rules should be the same. In the matter of the EFF versus the Speaker of the National Assembly, and I don't know where it is in the electronic, but can I give the citation? It's 2016, 3 SA 580 in the Concord. And paragraph 52 of this judgment, the Concord tells us how we should view the functions of the Public Protector. The Public Protector is thus one of the most invaluable constitutional gifts of our nation in the fight against corruption, unlawful enrichment, prejudice, and impropriety in state affairs. And there's a reason the Concord uses that word that we are running away from here, state affairs, and for the betterment of good governance. Close quote. And paragraph 55 of the same judgment says the following about the powers. It says her investigative powers are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. The predicament, though, is that mere allegation and investigation of improper or corrupt conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. An unfavorable finding of unethical or corrupt conduct coupled with remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be readily welcomed by those investigated. Close quote. I'm reading this quote to say this is how the Corn Court, not us here, how the Corn Court has looked at this. And this quote was made for this case, in my view, because we are dealing with two powerful constitutional beings, one of whom is the president. But of course what this paragraph says is that we must look at these powers of the public protector as powers that seek to protect us, not just now when we have someone we love dearly or when we hate somebody, but consistently for bad times in society. More specifically to the issues of jurisdiction in this case, because Judge Nugent, in the case of the Public Protector versus the Mail and Guardian, it's 2011, Volume 4, SA 420, makes more telling findings and suggestions about how we should look at what the Public Protector does and how we judge what she does or what he does. Because I may differ with how the Public Protector, my client, writes. I may differ with her. I may differ with how the previous Public Protector wrote. And maybe there are grammatical errors in the documents. And maybe there's wrong words used. But that is not the inquiry we have to make here. The inquiry we have to make is whether she has complied with the statutes and the Constitution. Now, Judge Nugent, in this case, says the following, and he commences his analysis about the scope of the PP's investigative mandate. And I will come back to the case where the JP, in a matter before this court, made the same point. He says, and this is paragraph 422, paragraph 6 of page 422 of the judgment. The Office of the Public Protector is an important institution. It provides what will often be a last defense against bureaucratic oppression and against corruption and malfeasance in public office offices that are capable of insidiously destroying the nation. If that institution falters or finds itself undermined, the nation loses an indispensable constitutional guarantee. And paragraphs 8, 9, 10, and 11 of the same judgment should guide us in our analysis of this case, and of course bind this court in determining the issue of jurisdiction. And paragraph 22 says, and I hope it should end all speculation about how broad we should be, what she could do. And the essence of the paragraph is approaching an investigation with an open mind. And it says, quote, I think that it is necessary to say something about what I mean by an open mind. That state of mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it is also not one that is unduly believing. It asks whether the pieces that have been presented fit into place. If at first they don't, then it asks questions and seeks out information until they do. It is also not a state of mind that remains static. If the pieces remain out of place after further inquiry, then it might progress to being a suspicious mind. But whatever the state of mind that is finally reached, it must always start out as one that is open and inquiring. Close quote. Justices, I make this point because a lot has been said about, no, she should have ended here. There was no reason to move further, even if more information came. She was still within her right to comply with what the SCA has said, to approach investigations with an open mind. New information may come, and she must not disregard it. In fact, paragraph 21 of the same judgment is more important because one gets the impression this PP is supposed to produce reports that surpass the writing and care demanded of the highest court. The scrutiny with which her writing her report that is applied in looking at it is far beyond what the scrutiny we use even to look at judgments of court. It may well be, as I said, that there may be a wrong topic, a wrong section quoted, but Judge Nugent says this about that temptation. I quote, "There is no dispute that an investigation and report of the public protector is subject to review by a court. I do not find it necessary to pronounce upon the threshold that will need to be overcome before the work of the public protector will be set aside on review. It would be invidious for a court to mark the work of the public protector as if it were marking an academic essay. But there is nonetheless at least one feature of an investigation that must always exist, because it is one that is universal and indispensable to an investigation of any kind, which is that the investigation must have been conducted with an open and inquiring mind." Justices, I think those court cases, together with many court cases that have dealt with this question, the Constitutional Court, and this. In fact, the Judge President says the same thing in the matter which related to what has ended up as the Zondo Commission. And I would like to go to what the Judge President sitting here today says in relation to this. In fact, in relation to both jurisdiction, 182, and this is the case, the President of the RSA versus the Public Protector, 2018, Volume 2, SA 100. It says, paragraph 78 thereof, the Judge President writes, "In Section 7, the Act gives Public Protector extensive investigatory powers. On receipt of a complaint, the Public Protector has the power to conduct a preliminary investigation for the purposes of determining the merits of the complaint, allegation or information, and the manner in which the matter concerned should be dealt with. She determines that. The Public Protector has the power to determine the format and procedure to be followed in conducting any investigation. The Public Protector is entitled to subpoena persons and require them to give evidence." In paragraph 82 of the same judgment, the Judge President writes, "As is evidence from the aforegoing, the Public Protector's investigative powers are of the widest character. Section 1821C of the Constitution requires that the Public Protector provide an effective remedy for state misconduct." And there again, the court, the Judge President uses the word state because it covers more than what we would cover if we were talking about public administration. And in paragraph 83, the Judge President says, it ought to be borne in mind that the Public Protector regularly instructs members of the executive, including high-ranking government officials, to exercise discretionary powers assigned by law to them. So the office asks those institutions, so there's nothing wrong with the remedial action. There's no price for guessing what they would do if they do not want to comply. But at least, as the court says, in interpreting what she can do, it says she can direct other organs of state not to do something that she likes, as we were told here, she's the new sheriff doing everything or wants to do all and sundry under the sun. No, that would be wrong. But to include those steps that can be taken by those bodies that investigate what she can't, because I think this acknowledges the fact that at different times, in fact most of the times, the matters that have to come to the Public Protector are matters that may fall within the expertise of other organs of state that can investigate them better and with more focus. What is required of her when she sees not proof beyond reasonable doubt that this has happened, but when it is there is a reasonable suspicion that there may be misconduct. And of course she would be wrong if she did that and made a finding that someone is guilty and therefore instruct matters to go to court. No, she acknowledges that the NDPP is the body to investigate further where there are shortcomings from her office. And of course, what does she do with the president? The Speaker, the National Assembly, is the only body to which public representatives account to the people, what I called in my 4 components of the state, the population. And that's what the legislature means.
Sorry, Mr. Sikukani, are you moving on to something else or not?
Yes, I was.
Okay, so I just wanted to come in there. My note on the M&G case suggests, and I may be wrong, so I speak under correction. It says that, and I'm more or less quoting, in paragraph 92 of the M&G judgment, the judge there said, or the court there said, the mandate of the Public Protector is in general confined to investigating the conduct of public bodies and functionaries, but also others in respect of public money.
Yes.
That seems to suggest a narrower reading than you have suggested.
Well, not that I have suggested. I think if we have to, I was quoting the Constitution. I think it's possible
it's your
that
interpretation of the Constitution, and that's why I refer to it as
I think that judgment, I've read that paragraph, refers to what he calls, and if you read only section 6.4 of the Public Protector Act, of course he is right. He is right because he is reading those additional powers in section 6.4. But what I'm arguing is what has been said in other cases, which is those are just additional to 1821C. They are additional to the power to investigate matters in state affairs.
The other follow-up question I had, and I appreciate, well, am I correct in assuming...
The judge is always correct.
No, appeal benches would disagree with you in my case. We give it our best shot. Would I be correct that this is not a question that has been raised before in the context of the Public Protector's powers? Is that correct? So would I be correct in saying that there's no question that courts have talked about the importance of her powers and the breadth of her powers and what she can do to investigate and so on? But if we look at, for example, what the JP said in the President versus Public Protector, what is not stated there, because it wasn't before the court, was the question of the ambit of her jurisdiction in the first place. So, of course, she can't no matter how wide her investigative powers are, she can't investigate or use them if it exceeds the outer ring of her donut, so to speak, of power.
Do you want my comment on this?
I don't think you'll disagree.
I will.
Oh, okay. We live in the...
I will, but not because you're wrong, because I think there's something incomplete in your interpretation. You know, the public protector can show you reports between students and the College of Medicines, right? That she has investigated many. And she has done so because they have put the matter to her and she deals with it and probably most of them suggest mediation. But the point I want to make is this. I'm not suggesting that she's the body to investigate everything under the sun. That would be wrong to suggest. But I'm suggesting that in respect of donations to a member of parliament by private donors who wants to become president of the party in order to rise and become president of the state are matters of state affairs. You cannot separate it.
Would the same apply if it was a very minority party?
Well, you could have a debate if that party is not going to have a president, where the benefit.
That's what I'm asking.
Well,
you know, we
exactly,
could
because
any
we are.
number of parties who've got one member. They're never going to have the
it
president.
may be different,
no
but
Mr. Motsoeneng said,
it may be different. They may not become president. Don't want to go there. Justice Kitley, I know this is beyond the point that we may want to say, but if you look, that's why I gave the 4 components of the state, because the Constitution acknowledges them, is that it may not be because the minority party it has a president, but it may wield some influence in the affairs of the population, the affairs of the state, that you believe that there's reason to intervene because the nature of their intervention in society is such that they are a big player in state affairs. They may not produce a president, and there may be reason to intervene. And I'm saying here, forget that you love Cyril Ramaphosa or you agree with him. Look at it this way. The president, who is a member of parliament, gets money from close to $1 billion from different people who are hoping he will become president of a ruling party. Of course, hoping to become president of the state. I am asking this court to interpret state affairs to include the fact that anyone who wants to be president of the ruling party and solicits or gets money benefits for that matter. Mr. Ngugaitobi says he didn't put money, he didn't get finances into his pocket and therefore we should be happy. No, benefits may be a number of things. Becoming state president is a benefit. And that is why the code that Mr. Malika will talk about encompasses that material benefit. Not necessarily that he got money. We've not accused the president of taking money. And so I want to ask this court to interpret state affairs to mean or to include a man or woman who's getting funding in order to get a benefit of being at the helm of the state. Any interpretation that is lower than that
Thank you.
is not correct.
That answers my query. Thank you.
Then Section 95 and 96 are important because we are told it's a private matter. 95 says before the deputy president, ministers, and any deputy ministers begin to perform their functions, they must swear and affirm faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2. Section 96 is more important for our present purposes. It's relevant because the President contends, or it is contended on his behalf, that the donations are a private matter that falls outside the purview of the PP, or the standard to which he must be held. And of course, we must not forget that before we came to this, I don't even know whether to read the documents we were told to conceal, because the President asked that we do not reveal documents that are part of the record. Of course, I'm going to indicate why this on its own is a problem for a President who's in the highest office who doesn't want to account. 96 says, 96.1, members of the cabinet and deputy ministers must act in accordance with the code of ethics prescribed by national legislation. And then it proceeds at 2, members of the cabinet and deputy ministers may not act in any way that is inconsistent with their office. And here's the important part. Or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, close quote. And I'm emphasizing the word the risk because if you heard my learned friends, you would think the bar is so high that it means he must not do something like engage in money laundering. Because the Constitution is aware that people who are members of cabinet, just like judges, are also private citizens. The prescripts that govern them acknowledge the fact that their conduct in private affairs are not always distinguishable from their office and sometimes have an influence on their office. Because when people are bribed, they are bribed at dinner tables, in their private homes, or wherever they sit. And what this tells us is that in exercising your official or private duties, you must not expose yourself to a situation involving the risk. And I submit that the funding by private parties for you to become head of state, we can debate whether they were really going to expect a benefit, but the risk exists. The risk that people don't just donate R1 billion for one man when they can't donate R1 billion for schools. There is something they expect. And so that risk, when you are going to be head of state, is the risk that Section 96 is talking about. And I submit to you, Judge President, and the two justices, that we should look at the conduct of the President in the context of what he is called upon to be. And with the greatest of respect, the President, if you read, and I can take you to the part, I think the President is much better in explaining his situation than it's been explained on his behalf. Because in one area, let's take the area of why he answered Mr. Maimane the way he did. You know, the President actually does a better job in this way. In an interview with the public protector, he says something that all of us as human beings can understand. Right at the beginning of that interview, he says, you know, I felt when that question was asked that the integrity of my family and my person were at stake. And I responded. Now, I'm not saying we should accept that explanation, but I think that explanation is understandable. It's different from saying, no, he didn't. He didn't mislead Parliament. He says, in the heat of the moment, I felt that my family and I were under attack. And I think that explanation, even if I believe that it doesn't save him, I think it's an understandable human reaction to attack. And that's why I'm saying he explains it better, because at the time he's explaining his state of mind, that he just feared, he thought he was being attacked. Now, the last bit, which is the case of the Constitutional Court, again, on this issue, it talks about the standard to which we must hold the president, any president. In the case of the UDM versus the Speaker, it's 2017 5 SA, page 350, it's the Concord. It says this about the standard to which we must look at the conduct of the president and accountability. Quote, accountability, responsiveness, and openness enjoin the president, deputy president, ministers, and deputy ministers to report fully and regularly to Parliament on the execution of their obligations. After all, Parliament is elected to represent the people and to ensure government by the people under the Constitution, close quote. That's slightly a better explanation of what the state is and what Parliament is. And therefore, this argument that seeks to separate Parliament as an entity that cannot be told by anyone what to do, itself is not in line with what the National Assembly is and what this case says. And in paragraph 10, the Concord continues. It says, it thus falls on Parliament to oversee the performance of the President and the rest of Cabinet and hold them accountable for the use of state power and the resources entrusted to them. Well, Section 92 of the Constitution, I would like us to take note of it as well, because it's important about what members of the Cabinet should do. It says members of the Cabinet are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions. My Lord, I submit that these sections and what this court, in the context of a different public protector, has said should apply here. And if we apply it consistently and objectively, and we hold both the current president and the current public protector to what they are obliged to do, this court should find that she was well within her powers to investigate matters of this nature. And therefore, the point about jurisdiction is untrue, should fail. The court will remember that the facts of this case are as follows, and I will summarize them because we've done them in our heads of arguments and the affidavit. The public protector received 2 complaints, both of which related to his conduct. The first complaint was received and lodged on 23 November 2018 by Mr. Mkhwebane, the then DA leader, alleging the violation of the executive code by the president. The second complaint was received by the PP on 26 January 2019, as well as an anonymous complaint on 28, which came on 28 January 2018. Sorry, I think it's 2018, so I said 2019. Mr. Shibambu, who was the complainant in the second complaint, alleged that during the President's appearance in the National Assembly on 6 November 2018, the President had said that his son, Andile Ramaphosa's company, had a contract with African Global Operations for the provision of consultancy services, which deals with issues of integrity, anti-corruption, and claimed there was nothing untoward. Well, my Lord, if you look at the letters of complaint themselves, the court will find this in volume 1, and it's page in the new pages. I use the order, but it's page, it will be 0111. But it's page 11 of the report, sorry. It's page 82 of the volume. This is what the PP says as an introduction to the focus of the investigation. Quote, based on the analysis of the 2 complaints lodged by Mr. Mkhwebane and Mr. Shibambu, the complainants, and having taken into account the fact that President Ramaphosa was the then president and thus a member of the National Assembly, the following issues have been identified to inform the focus of my investigation. And then she proceeds to identify them. I do not have to go through them. But she then, in that, the court will find that she deals with specific questions that she wants to deal with. But the first one is simpler for us to get through. More difficult because we want to get into the areas of intention, which we can't determine here, which is, did the president mislead Parliament? Of course, I don't want to put it higher than that, to insult our president. No, because mislead is a different word, and I think it's used like that for a different purpose. It says, well, let's look at what the proceedings on the day. If you want to determine whether we can conclude that the president misled Parliament, three things must be looked at. One is the question, the nature of the question that was asked. It was a supplementary question. Did the president have to answer it unprepared? No, he actually didn't. In terms of the rules, he could have said, Mr. Maimane, go fly a kite, I need time. I want to answer you when I've had a look at this. That is done because you are avoiding misleading Parliament. So when people catch you off guard in Parliament, as they always do, because you must not mislead Parliament at that point when you're there, if the question is a supplementary question that was unrelated to the first one, you have the opportunity to go home and prepare for it. He didn't have to. The second issue is, what was the question? What are the details in the question? Because you can only determine what the president knew if you look at the specifics that are in the question by Mr. Maimane. And I invite the court, as we do in our heads and in the founding affidavit, to look at the specifics. And here is one specific. In fact, two. First, did the president's son have a contract that the president saw at close range with his son? I think we can forgive the president here for stating that there was, because I think eventually when you look at the facts, a memorandum of agreement emerges that is signed by the president's son. So I think on that basis, just on that question, on that issue, I think there is something the president may have seen. Well, the next question is, what's specific in the question is EFG2 account.
So to come in there, Mr. Khan, Mr. Shivambo's question, or Mr. Shivambo wanted the public protector to investigate whether indeed the president's son had a contract with Africa, with the SAS.
Yes.
Now, I tried to, maybe you can help me, where in the papers does she make a finding that yes, the president's son has a contract, or the president's son does not have a contract?
I will get to the report. She talks about it. I will get there, because there is reference to the contract, which is the contract, the memorandum of agreement that was there. But that memorandum of agreement has nothing to do with the payment about which he was asked.
I'll tell you why I'm asking
Yes.
you this question. Because if we accept that the president's son had a memorandum of agreement with the SASA, shouldn't we then accept that maybe the president was telling the truth when he said, yes, I've seen the contract, my son has a contract with the SASA?
You may be forgiven for that aspect, yes. But I do not think we should.
And whilst on that
Okay.
question, so that we can deal with these issues that are bothering me.
Yes.
My man's question to the president was, look, I've got proof. Money has been paid into your son's account. And the president's response was, I have seen the contract. My son has done work for the SASA. That money was payment for services rendered. Is it not my money who misled the president?
Yeah, I've heard.
Because he got the president to focus on the money that, according to my money, was paid into the president's son's
I've heard this argument made this morning. It's bizarre. It's bizarre in this way. That, you see, Mr. Maimane asks the question, and I'm not saying it was an elegant question, but to say the president must be forgiven because in the question, it is Mr. Maimane who says that your son was paid, does not absolve the president from stating what is true. It's really a bizarre argument. I heard it. They may both be wrong. Maybe you want to accuse, we may accuse Mr. Maimane of not being clear about the question she was asking, but it's not his conduct we are dealing with. We're dealing with the response. Forget what Mr. Maimane said, and maybe he was wrong. We will deal with it, why he was not clear to our president when he asks a question. But the question, Justice Matojane, you should ask yourself, we're analyzing the conduct of the president. Did the president give Parliament, in answering that question, a fact that was true? That's the question.
But let's assume that the president's son had a contract with Busasiwe, and my money says to him, I've got proof. I've got a son affidavit to the effect that money has been paid into your son's account. And the president says, I have seen the contract. My son has done work for Busasiwe. Is that misleading when he answers a specific question by my money?
We don't have to analyze that way what he says. We have to ask one question, because he says, this matter has been brought to me some time ago. So we're not talking about the president who doesn't know the facts. He says so himself. So I'm saying, even if Mr. Maimane's question is inelegant or unclear, but at least we know he's asking one question. Was 500,000 rand not paid to the EFG account? And the president, of course, was at liberty to say, I do not know those facts as I sit here. I will mislead Parliament if I try to answer your very unclear, confused question, Mr. Maimane. He should have said that. He could have said that. In fact, the rules protect him from answering a question like that precisely because he must not say something that is factually incorrect in the National Assembly.
But let's assume, in his favor, I'm not saying I'm agreeing with him.
It's okay.
The president is saying, I wasn't aware that this money that my money referred to was paid into my campaign. When he answered the question in Parliament, he's responding to my money's question that money has been paid into your son's account, and his response is, I've seen the contract for money for services rendered.
And well, let me ask a question. We can both answer it. Was he right in that answer? No. This very person, this matter had been brought to him some time ago. I quote him. And by the way, in his answer, and that's why I want us to go to the president, so that let's analyze what he said, not what we think. Let's analyze what the president says in response, in very certain terms. In fact, he starts by saying, I can assure you. And he says, it's Annexa MCR3. The president's answer is this, and I think it will help us rather than analyze him out of context and unfairly or too favorably. Speaker and the Honorable Maimane, this matter was brought to my attention. It was brought to my attention some time ago. If we hold it right there, we're not dealing with a matter the president is unclear or unaware of. He says it himself. I proceeded, he says, to ask my son what this was all about. Right? Very specific terms. He doesn't say, well, maybe, I'm not certain. He runs a financial consultancy business. And he consults for a number of companies. And one of the companies is Busasiwe. President quite remembers details here, where he provides services on entrepreneurship, particularly on the procurement process. He advises both local and international companies. Regarding this payment, now we don't have to guess or favor the president or prejudice him. Let's see what he says. Regarding this payment, and how much? 500,000 rand. So he knows what Maimane said. I can assure you, Mr. Maimane, he doesn't say, I will check, but I think, no. I can assure you that I asked him at close range. And what is the subject of this is the payment, regarding this payment of 500,000 rand. So he doesn't say he doesn't know, doesn't say he thought it was something else. I asked him at close range whether this was money obtained illegally, unlawfully. And he said this was a service that was provided. To this end, he actually even showed me a contract that he signed with Busasa. The contract also deals with issues of integrity, issues of anti-corruption, and all that. But can I make this point? Because it's a debate Justice Makhwebane read with me. If you read what the president says, and the information that he claims he had, that the matter had been raised, we are left with no doubt that he knew what he was talking about. And when he refers to the payment was stated. He could have said, I don't remember, I don't know. I will come back to this point later so that we can compare the facts and the president's subsequent correction. And I'm saying this because in the answer, the president tells us the person he had a discussion with at close range. I can tell the court now, in the subsequent letter, probably written with the assistance of lawyers then, the president does not say, even in the affidavit, after this skirmish, this issue that concerned him, I went back to my son. You would think that's the first port of call. This person he asked at close range. No, he doesn't. In fact, he couches it at the level of generalities. I have been subsequently informed, he says. He doesn't tell us that I have gone. In fact, he says it's Miss Donay Nicole. And I'm saying this because if we are inclined to say that the president did not mislead Parliament, the facts do not tell us that. The certainty with which the president answered this question when he didn't have to answer it should tell us. I am sympathetic to the explanation that he gives later, but it doesn't help us legally that I felt attacked, I felt under siege. We all do, but it's not an answer to this. Therefore, I submit that the suspicion or the allegation that the president misled Parliament, if you look at his own words and what subsequently happened, and the fact that he himself writes the correction, he misled Parliament when he was not compelled to answer that question. When he actually, as we find out, says, when he said about this 500,000 rand, this payment, now we must believe that he didn't know what he was talking about. He says, we've been told it was about facts that were at his disposal at the time. What facts? What were the facts that the president had at the time after speaking, having been told about this matter, about this payment? But the facts that we know are not consistent with what he says and the answer he gave. And if we do not favor, we offer him no sympathy or favor in our interpretation. And it's not because the president is going to be impeached, no. But the truth is that he acknowledges it himself, that the answer he gave was incorrect. And of course that led to the question about whether it was deliberate or willful. I don't know the difference between deliberate and willful. But the problem is that there's use of the word inadvertent, right? that somewhere she uses the word inadvertent and deliberate. When I said earlier that materiality of this confusion is important, suppose she incorrectly at some point made reference to the words deliberate and inadvertent. And the other, perhaps the correct section, talks about willful. Well, the word deliberate, I would like to persuade the court, and willful mean the same thing. And therefore, the consequence of the two words he used and willful is in another is not there, is immaterial. Because the fact of the matter is that on the version of the president, his answer in Parliament was incorrect. And may I say that we are unable, I heard someone saying we can't, what was his intention? We are unable in this court on these papers to deal with that issue, the issue of what the president intended. What we know is that the answer was incorrect and should not have been given.
Mr. Sikakane, just a point of clarity for me. I understood that the first applicant's complaint was about the confusion the public protector had, they say, between willfully and inadvertently.
Well,
not the willful and I understood that was the confusion, and of course there's a huge difference between, let me not say of course, it may be argued that there is a plain difference between willful and inadvertent. Just a point of clarity, I wonder if you're going to address us on that, or if
let me deal with it right now.
Perhaps you and I just aren't on the same page.
No, we are.
Sure.
Let me deal with it right now. There were words that were used during argument that are not necessarily used here. The word inadvertent, let's go to the report itself and how it's used. The word is used together with deliberately, right? And so, it's not correct to say where she used the word inadvertently and deliberately. The problem, where I would criticize how those words are put together is because there is inadvertently and or deliberately in the same phrase. But it's not inadvertently on the one side and willful on the other. The two, that error, it's inadvertently or deliberately or willful misleading of Parliament. The President, since he didn't willfully mislead Parliament.
Her finding
Yes.
is that he's in breach of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading.
Absolutely.
But the code we know, because the public protector says, yes, I had the wrong. It says willful, which is different to inadvertent or not.
Can I take this slow again, because it's the point I started with when I answered. This is immaterial because the word, when you started your question, Justice Kitty,
yes,
you said they say inadvertently, right? And where you've read just now, and
yes,
it's consistent with the answer I gave you, and that's why I say it's immaterial. She may have used the wrong phrase. It's inadvertently and deliberately. That's what you read to me. And the other one, which is willful. I am saying the word willful and deliberate mean the same thing.
No, but I didn't understand that to be the complaint. But I think
But
I understand what you said.
in fact, the complaint itself uses the word deliberate. But to argue as if in her report you will find a finding that says just this word, inadvertently without the word deliberately, is mischievous. And that's why I say the question of materiality is a point I'm making, is that suppose she had used the other one, which is willful, and not the one that is deliberate and inadvertent. What difference would it make? And I'm saying the law tells us, and our cases have told us, no matter how much we want to explain something of that nature, It's immaterial. It's form over substance. We are told again that the public protector did not satisfy herself that there was money laundering. Let me quote the same case that the Judge President dealt with, which is the President of the RSA versus the Public Protector, 2018, Volume 2. The Public Protector, the Judge President says in paragraph 12 of this case that prima facie evidence which points to serious misconduct is a sufficient and appropriate basis for the PP to take remedial action. I'm saying that because what she has to deal with, and I think she acknowledges this in her report, and I think it must be acknowledged, that she has no capacity in her office, and it's not part of her office, to really look into the issues of money laundering, of the crime of money laundering. And I think it's for that purpose that the court here says it is sufficient that she sees evidence which points to serious misconduct. That is sufficient. It may well be that when the matter went to the body that must deal with this, which is the NDPP would have found that not all elements are met of this crime, and therefore I have no case. The remedial action is not, please investigate, try, and convict. It says, I see this, I'm not the body to determine whether it's a watertight case. But as a public protector, I see this that I think, in my opinion, points to serious misconduct. It's not all the elements of the crime, because the bodies that are tasked to do that will. And I submit, Judge President and Justices Kitley and Matojane, that if we really look at her role, what she saw is sufficient, not for her to find the president guilty, she can't, but it's sufficient for someone who's tasked to protect the public to say, I will send this to those authorities that know better than I do. It is rational. Anybody in her shoes, faced with this information, would have done the same. It's the rational thing to do. If the public protector had said, the president is guilty of money laundering, she would be wrong. She has no competency to do that. Her office cannot do that. And therefore I submit that this court must look at the cases that have analyzed this office and its powers previously and apply consistently the same rules in looking at this public protector and what she did here. Now, of course, we are told that one of the reasons the CR17 campaign is outside her reach is because it was designed to renew the ANC, to make sure, Mr. Mkhwebane says, that the ANC goes back to its values of honesty. I'm no expert on the ANC, and so I don't know whether it has left those values, because it's not a matter we must determine. But the point is this. We invited the president to demonstrate to us that this was a party matter. We invited the president to do that in the affidavit, to show us, because we provided the statement of the ANC itself as a body, because I don't think any of us here as lawyers or the president outside that party can speak for the ANC. We have got no evidence. Easy. They would have gone to the ANC in the office and say, please give us the even if no money went to the coffers of the ANC, in order for it to be a party matter, as they say, to renew this party, done by external people, the ANC could not give them that. We invited them. Give us the ANC saying this CR17 money was to renew the ANC. It didn't come. In fact, they didn't answer the question because there is none. Because it was not a party matter. Because we know the statement of the ANC tells us what this was. We invited them to get another one. Show us this was money to the ANC to renew it, to go back to what Mr. Mkhwebane says, its values of honesty that obviously have been lost. And the ANC says this. It's page 862, 02862.
02? That's 02.
862, the statement. There is the statement of the ANC. It's the only statement we have of the ANC, and I invite the court to look at it. It's critical of the leaks, it's critical of different things, but nowhere does it repeat what was submitted to this court, that CR17 was to renew the ANC. In fact, we know now, the little I know about parties, and the ANC in particular, is that it would have been easy to trace the decisions of the ANC about renewing itself and having CR17 as a campaign for the party to do that. The campaign was for the election of the president of the ANC. It was his personal campaign. It was not the campaign of the ANC as a party. It was the campaign within the ANC. But the beneficiary, we are told that because there were 80 other people, therefore the benefit was not for the president. That's just illogical. It's just illogical. If the president is part of that 80, it really doesn't matter that he benefited with 80 other people. The fact of the matter is that he benefited from this in something that would make him president of the country. Therefore, the issues that we've been told about here, about jurisdiction, about the fact that the president didn't mislead Parliament, those submissions are incorrect. The president was invited. I invite the court to look at the transcript of the meeting between the president and the public protector. It's common cause. The public protector wrote to the president, invited the president. They sat and spoke about this matter. The president responded to the notice that was given in terms of Section 7(9). And when we speak here, we speak of a preliminary report and this. I think there's a reason why one party calls it a report. We call it a 7(9) notice because this is what 7(9) says. And my learned friend read it. And there's a reason people don't call it what it is in the statute, because they want to broaden the scope of what was required for her to do. Because this is what she does during the investigation. It's not like one of those decisions that you are going to make and you alert the party that is involved. I'll make an example what 7(9) is like. It's like Rule 3.3 of the Zondo Commission. It's exactly that. If, as you look at what is before you, in fact they read the same, it is clear to you that the person is implicated during the investigation. So you are investigating, it's ongoing. That person has the right to make representation. You may invite the person. In fact, the statute itself, Mr. Kong have read it, and I don't need to repeat it. The point I wish to say is this, is that the president was served with that notice. And that notice, which happens during the investigation, not after, it is sufficient for that notice to indicate possible findings. In fact, that is how it is phrased. It's the findings. not actions will take. Mr. Trongov went as far as making an example of a criminal trial. No, it says give them the right to make representation during your investigation. So it's not complete. And therefore I submit to this court that it is rather harsh when all of this is done and we know the responses of the president to say he was not given Audi. There is no legal requirement for what we are told is, well, should have indicated the remedial action. May have. The issue of giving parties an opportunity to be heard is context specific. It depends on the circumstances of each case. And I wouldn't be surprised if in a matter of this nature that is so sensitive and high profile, and you wrote something that indicates what you want to do in the middle of your investigation, you could be accused of prejudging the matter. So the circumstances of this investigation are that it was correct to send the 7-9 notice and alert the president of all possible findings. In fact, elsewhere, it actually does say that the possibility is that these issues may be referred to the relevant authorities. I submit, therefore, Judge President, Justice Kitley, and Justice Matojan, that the point about Audi is entirely misconceived. It ends there. The president was given every opportunity to respond. Then we are told that her findings have no factual basis whatsoever, and therefore the conclusions are irrational. I have already stated what the test is, what it is that she must see, and then investigate and refer to other authorities. Our learned friends say the public protector just emerges with the findings about the possibility or suspicion of money laundering. My lords and my lady, I want to invite you without reading it. I don't want to read the documents and emails and everything else that show that the president, even the suggestion that he knew nothing, the email we have from him to a certain Mr. MacDonald, he's directing how money must be exchanged. But without going to something that explosive, if you look at the information that is obtained from an organ of state, the FIC, at some point we were all accused with the FIC of acting unlawfully. It shows you that looking at the flow of money from different accounts. Now, of course, the public protector doesn't have to determine whether or not crime of money laundering has been committed. And so we must be careful when we set this test, where we set it. It's whether she is satisfied with the skills that her office and the functions of her office, that there is a reasonable suspicion of money moving from different accounts. What is the reasonable thing to do if you've seen different accounts and money flowing from one account to the third until it reaches the next? Is that she sends it to the authorities that deal with it. But she says the suspicion, in my view, is substantiated. She doesn't say the president has committed money laundering. She says, I will send it to those that will look at it. In fact, even the FIC affidavit, it's not small that we said our learned friend quoted one paragraph of the FIC and not the other, 87 and 88. It's because 88 of the affidavit of Ms. Kanyele, that affidavit, tells us, she says it honestly, that look, we were not looking at the crime of money laundering. We're not the body to look at that. The same with the public protector. She has to look at whether there is enough information for a suspicion in her view that some more work must be done by those authorities that would look at it. And it would not be an indictment on her if the authorities that she refers matters to say, we don't think all the elements of the crime of money laundering have been met, therefore we are not investigating. The fact that they say that is well within their mandate, statutory mandate, but it is not wrong for her to refer it to them. And therefore we suggest that even all the accusations, I don't know whether they are still made here, that she stole documents or she used stolen documents. No, these documents were not stolen. That the FIC information was leaked, was unlawfully obtained. It's not true. It's just that it's legal points made to fit into a narrative, and therefore it doesn't have to justify itself. And I think it's important to look at what the law says if we're judging people, and it doesn't matter who they are. Because next thing we're going to have is people can come here and recite Hail Mary full of grace as long as they know that whoever they are defending is liked. And my point is this, is that our learned friends don't rely on what I think are proper authorities about the conduct of the president, because they know that the president was, on the conduct of the PP, because she was right in terms of our cases, on jurisdiction, on Audi, on remedial action, and rationality. And therefore, we submit that if you look at the facts, and all the people that she invited to speak to her, she went out of her way to get as much as she could, not to convict the president, but to see whether there was reasonable suspicion for her to send it elsewhere to more competent bodies. And I invite the court to find that she did what this court said Thuli Madonsela has to do. What this court has said is the job of the public protector. What Nugent in the SCA has said. It would be a travesty of justice if all of those cases don't apply to this public protector. And therefore, before I move for my Leonard Jr. to deal with those small issues, the submissions that we make may be summarized as follows. First, the first applicant is wrong that there was no jurisdiction. Absolutely wrong. Section 182 and a proper interpretation of state affairs means that the public protector was well within her rights to investigate this matter. The facts reveal that on many occasions the president was given a chance to be heard. The PP doesn't have to agree with the president and what she presents, and there's no requirement for that in administrative law. She must look at that and still come to a conclusion. The court may not like her conclusion, they may not like her conclusion, I may not like her conclusion, but that is not justification for judicial interference. The question is whether she did what she had to do. The third point is that it is quite clear that if you judge by the question that was asked to the president and his answers and the facts that we know, and the letter of the president himself, he did mislead Parliament. The answer he gave was incorrect, and he shouldn't have, because he had every right not to. Lastly, I submit that the test for rationality, if one wants to find whether it was reasonable to suspect, not to convict, it was reasonable to suspect in terms of her duties, that there was something he could send to more competent bodies. The facts of this case and the monies that exchanged hands between this account to this account before it reached another are reasonable for a matter of this nature, for the high office, the highest office in the land, to disclose a benefit of that nature. Because if you look at Section 96, a public official cannot say, oh, sorry, I received R1 billion privately. It's exactly what Section 96 was trying to cure. Is that in our private lives, as powerful as we are, and it doesn't matter who you are, you have to watch your private life, because it can create, you may be in a situation that can create a risk that those who funded you want contracts when you are president. It's very possible. It's a risk. And therefore, Section 96 tells us that the facts of this case, the monies that were exchanged and how they were exchanged, may not mean that the president is going to jail for money laundering. No, because that's a different test altogether. But they are sufficient for an administrator, an office, a constitutional body like the Public Protector, to say, I see things here that I think, in my opinion, look like transactions that are suspicious, but I'm sending it to the right bodies. We therefore submit that there is no case that the president has made here, that each and every ground is not borne out by the facts of this case. And all the facts of this case and what this court and others have said support the case made by the Public Protector. I will ask my learned colleague to finish up on the costs and the remedial action, unless there are questions from the bench.
Mr. Mkhwebane, thank you for submissions. We've reached the end of the time for today. You've used 1.5 hours. She's going to deal with the Speaker's case and the NDP's case. Is that it?
And the information regulator a bit, but she will finish it in the 2 hours we were allocated.
Okay, no problem.
I've used 1.5.
Yes.
She has 30 minutes.
No, you insisted. So the court will adjourn for today. We'll reconvene tomorrow, promptly at 10, and continue the meeting. Thank you.
Sitting in a massage. I know that's not good. That's what you need.